Mr. Chair, you have a quorum.
Thank you, MJ. Welcome to the this is the fourth meeting, I think, of the Senate Courts of Justice Committee. We have looks like a couple dozen bills in the docket. We have a couple of housekeeping things we need to take up. First of all, Senator D. Staff has requested that Senate Bill 193 be stricken from the docket. Is there a motion to strike the bill? So moved. Second. It's been moved and seconded. Senate Bill 193 be not from the docket, just struck. Struck. Clerk will open the roll.
Ayes 9, no 0.
Okay. Secondly, Senator Lucas has asked that Senate Bill 588, which is about affordable housing and criminal record screening, be carried by for the day. And Senator Bagby has requested that Senate Bill 625, about deferred installment payment agreements, be taken by for the day. Is there a motion that those be taken by the day in a block? It's been moved and seconded to be taken by for the day in a block. All those in favor say aye. Anybody opposed? No. Okay. Those are taken by for the day. First, we're going to have up Senator Rouse and then Senator Hashmi, then Diggs, McGuire, Reeves. Senator Rouse, you have which one?
SB 355.
355, Virginia Self-Storage Act, which I think conforms the Self-Storage Act with the Landlord-Tenant Act, pretty much, right?
Yes.
Okay, if you want to say anything else, explain the bill.
Just a quick summary, Mr. Chairman and members of the committee. The Virginia Self-Storage Act permits a rental agreement to be delivered and accepted electronically. The bill permits a rental agreement to contain statements that the rental agreement is deemed accepted by the owner, where the owner accepts rent, or where the occupant accepts possession or delivers rent. And finally, the bill just permits towing of any abandoned, immobilized, unattended, or trespassing vehicles or watercraft that are not authorized to be at the self-service storage facility. And also have an expert here if there are any questions.
Okay. Is there any questions for Senator Rouse about this bill? No questions. Senator Rouse, one question that I was given. If you could turn to line 69 really quick. You got the bill up there?
Yes.
Talks about how if line 34 and 35 allow for electronic delivery and acceptance, whether line 69 should also allow for either mail or electronic delivery.
That was a great question. I'll bring my expert up to respond to that, Mr. Chairman.
Okay.
Mr. Chairman, members of the committee, David Halleck on behalf of the Virginia Self-Storage Association. Repeat the question, Mr. Chairman.
The question is that because lines 34 and 35 now allow for electronic delivery and acceptance, should line 69 also allow for either mail or electronic delivery?
Amendment. Yeah, I think that would clarify, but.
You think that's a good idea?
Yes. Yes.
You guys are good? Okay,
Yes.
Is there a motion to make that? Okay, it's been moved and seconded. We add in concept electronic delivery and acceptance to line 69. All those in favor say aye. 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 Anybody opposed? Nobody's opposed. Okay, any other further discussion? Anybody in support of the bill besides Mr. Halleck? Is there anybody opposed to the bill? Okay, is there a motion?
Mr. Chair, we move to report.
It's been moved and seconded to report the bill to the floor. All those, or the clerk will open the roll.
Ayes 12, no 0.
Great, thank you, Mr. Rouse, or Senator Rouse. Senator Hashmi, you're up to bat with the bill we heard last week. We already heard most of this bill. Senator Hashmi, have you had a chance to work on it with some folks?
Yes, thank you, Mr. Chair, and members of the committee. There is a substitute in front of you. I think the sticking.
Okay, it's been moved and seconded. We adopt the substitute. All those in favor say aye. Aye. Anybody opposed? No. Can we distribute the substitute?
Mr. Chair, the substitute is already up on the dais with each member, and it should be online shortly.
Okay, go ahead, Senator Hashmi.
Thank you, Mr. Chair. So I think one of the sticking points that we had last week was the issue of non-confidential data. And the only data that we really want or need to have clarity around the eviction concerns in the Commonwealth is the addresses, but the identification of names and individuals that has been taken out of the legislation. So what would be reported are just the addresses of where the eviction is occurring and amount of money that's claimed in the action. And again, this is purely for research purposes within our four-year institutions and requests made by faculty members. If the chair will allow, I do have a faculty member here from our eviction lab at VCU who may be able to speak to some of the concerns about maintaining confidentiality through the IRB process at a university.
Okay, Senator Deeds, I think, had some questions about this last time. Senator Deeds, you got any other questions about this at this point?
I think this is okay. What I was concerned about was the name, and that's taken out in the substitute. It's just the address, and I've talked to folks, I guess, from the Poverty Law Center, understand why it's important to identify the address so that you understand whether there's a pattern in a neighborhood. I get all that, so I don't have any problems anymore.
Okay.
Mr. Chairman.
Senator Stewart.
Thank you, Mr. Chairman. Senator Hashmi, I'm just curious, and I don't know if I asked this question last time or not, but on the substitute, who enforces? I mean, I understand the bill says that you can't use it for commercial purposes and it must be kept private. What enforcement mechanism do we have for that? Are there any damages if somebody does? What do we have in this bill to hold people's feet to the fire with regard to keeping this information private?
Thank you, Mr. Chair, and thank you, Senator Stewart, for that question. The Institutions Review Board has a process, and if the chair will allow, I can have our researcher address that concern directly. It's the institution's processes that are in place that protects this data.
Thank you, Mr. Chair, and Senator, for your question.
Sorry, can you identify yourself and say who you're with?
Yes, my name is Benjamin Teresa. I am an associate professor at Virginia Commonwealth University. I'm also the director of the RVA Eviction Lab. So if I understand your question correctly, you're asking about the process by which kind of enforcement of confidentiality and protection of privacy with personally identifying records. So all research projects that engage with personally identifying information, like street addresses, are required to go through the Institutional Review Board, the IRB at VCU. And so all projects, before we begin, have to be vetted through a team of experts who look at the project and look at what protections are in place. So this would mean having appropriate electronic security protocols. All that information would be under encrypted, password-protected types of protection.
Professor, this is all data that's going to be anonymized. I mean, the names have been removed from it, so all we're talking about is the amount of a judgment and addresses associated with the judgment at this point, right?
That's right. That's correct. That's what I understand.
Mm-hmm. And Senator Hashmi took the names out, Senator Stewart.
And what I meant by identifying information was just the street address, which is considered a type of identifying information, at least for research purposes.
Okay, Senator Stewart, do you have any other questions, or does that help? Okay, I think
Thank
we're
you.
good. Okay, does anybody else have any questions for Senator Hashmi? Okay, the bill does not need to go to, or does it need? It does need to go to finance, doesn't it? No, it does not. Okay, the bill does not need to go to finance. Is there a motion on? Senator McDougall has a question.
Mr. Chairman, it does contain.
Senator Stewart has a question.
No, I'm correcting you. It does contain the street addresses
It does.
in the action, so that's an identifying information.
Senator Hashmi.
Mr. Chair and Senator Stewart, yes, it contains street addresses, and the purpose of that is to be able to identify more closely and accurately where the crisis of eviction is occurring. So if we know that certain neighborhoods in particular have a higher than normal rate of eviction, it helps our researchers understand patterns, understand situations. At present, the only data that we're able to collect is by locality, and that's where the problem is. So we might say Chesterfield County, for example, but that doesn't help us identify which areas in Chesterfield County are facing higher concerns around eviction. And again, as Dr. Teresa pointed out, the IRB process protects even that information of the street addresses. That is not something that would be publicly released.
Senator McDougal.
Mr. Chairman, can you show me where it's required that the research be an IRB-related process? Because not all research has to go through the IRB process.
Mr. Chair and Senator McDougal, it's my understanding that any large research project within an institution, a research institution, must go through the IRB process. That's fairly standard, and this data is only going to research institutions. So, for instance, a researcher at a community college is not accessing this information, but only our research institutions.
Mr. Chairman.
Senator McDougal.
I understand that many projects go through that IRB, but I don't think they're required to go through that IRB process. So if that's something that we're trying to make sure that only projects that are approved through that process are allowed to access that information, I think that would be an additional protection.
Senators, Mr. Chair and Senator McDougal, I don't have any problem with adding that clarifying language as a friendly amendment, should you propose that.
Senator McDougal, you want to make an amendment? Or? Take a 5 for a minute.
I was saying under line for 59, for purposes of academic research that was approved through the institution's IRB process. I guess it's IRB committee.
IRB stands for what?
It stands for board. The B stands for board. So you could just say Institutional Review Board.
Council, who's this? Sabrina, you got it. Okay. You got an amendment for us?
Mr. Chair, if I could just ask a clarifying question about the IRB. Is that one board, or does each school has one? Okay. So, Mr. Chair, if we're looking at the substitute at the beginning of line 60, we would add may request for it would be at line 60 after research and we would insert that has been approved through such public institution of higher education's institutional review board.
It's been moved and seconded. We adopt that amendment to add this IRP process to the bill. RIB. All those in favor say aye. Aye. Anybody opposed? No. Okay. We've made that amendment. So we've already done the public testimony piece. I think we might have to continue to have some dialogue about this. Any further discussion about the bill? Questions? Questions? Yeah, sure.
Senator Hashmi, I don't dislike your bill. Don't misunderstand what I'm saying. I'm concerned about people where you're trying to help and they may actually be injured as a result of this information because they could figure out who they were, where they were, who they were. And if the information is not used appropriately and someone is harmed, there's no penalty for that. There's no liquidated damages provision for that, and they're not going to hire a lawyer and try to sue somebody if they lose their job over it or something else happens to them. Have you considered that, or are you amenable to looking at some sort of penalty and a liquidated damage provision if the privacy aspect is violated?
Mr. Chair and Senator Stewart, I think your concerns are important. I don't think that this would happen in this particular case in that there is really no identifiable data that would be reported. It would not be reported publicly as to the specificity of the street address in any kind of public report that the researchers would make. Rather, it would be around issues of neighborhoods and communities, identifying which localities in particular have the crisis of eviction. And so it is not, I'm not concerned with regard to what you're saying. I'm not concerned that information will be presented in such a manner that individuals will be so specifically identified that that may have an impact on employment opportunities or credit opportunities. This is simply enabling our academic divisions to get granular data, the kind of granular data that we really need to see around evictions, and then to translate that data, translate that research into policy recommendations for us to take into consideration. This is the kind of data we have really been asking for so that we can better understand why out of the top 10 localities in the United States, 5 of those cities and localities are located in Virginia. Why is it that Virginia in particular has such a substantial crisis of eviction in comparison to other states? So this is what the data would help us to achieve.
Mr. Chairman.
Yes, Senator Stewart.
So I take it you really wouldn't view it as a friendly amendment if we put a penalty or liquidated damage provision if anybody is injured in here?
Mr. Chair and Senator Stewart, I don't think there's any need for that amendment because the IRB process protects the researcher, protects the institution, protects the data.
Is there any other questions for Senator Hashmi? Okay, is there a motion? We already heard this, Bill. Is there a motion? Anyone? What are you moving? Okay. It's been moved and seconded. We report the bill.
As amended.
As amended. The substitute, sorry. All those in favor? Clerk will open the roll. All right, Senator Hodgson.
Ayes 9, noes 5.
I think you do a little more work, you might be able to get those votes locked down, but we'll talk about it offline.
Thank you, Mr. Chair.
Thank you, Senator Hashmi. So next on the docket, I show Senator Diggs. Senator Diggs, are we back here on a bill we heard before again?
666. He's got the devil's bill.
Yeah, you got the unfortunate
Yeah,
number.
I'm not
and
pleased
then
with that, yeah.
What do you want to do first, second? I guess we get 3. What do you want to do here?
Whichever your choice, Mr. Chairman.
Yeah, you got some dicey ones today. Let's see. Let's go with, where's my sheet? Let's go 666 first. The devil's bill.
Thank you, Mr.
Feeling lucky, aren't you?
Thank you, Mr. Chairman. Currently, the Code of Virginia prohibits registered sex offenders from being near certain recreation facilities such as playgrounds. The provision of the code as it is today only applies to parks owned by a locality such as a town, city, or county. There is not a provision that prohibits registered sex offenders from being near recreation facilities within state parks, and this legislation would amend the code to afford these same protections to state-owned recreation facilities, thereby increasing the safety and protections of our children that are using state parks. It would apply to sex offenders who have been convicted of a crime that prohibits them from being in contact with a minor. and this creates consistency across all of the recreation facilities in the Commonwealth that may contain children or minors.
Thank you, Senator Diggs. I think Senator Deeds has a question.
Senator Diggs, are there examples of sex offenders near state parks that have caused problems?
Yes, sir. I have several. I can find them. I know that certainly there were some in other states.
But
Well, this seemed to have eluded me. I knew I had them.
I'm interested specifically in Virginia.
Not that I'm aware. There could be someone here that could speak to that.
Sorry, it looks like you got a friend here. So.
Mr. Chairman, members of the committee, Matt Wells, and the Director of the Department of Conservation and Recreation with the parent agency of state parks. Appreciate the opportunity to answer the question. The answer is yes. As Senator Diggs said, right now, if you're an individual who's been convicted of a sex crime against a minor, you are prohibited from going to a school, a daycare, or a local park for the intent of having contact with children that are not yours, but you are not prevented from going to a state park. To give you an example of how this loophole impacts us, we had an individual who was loitering in a bathhouse in a state park last year. When we got the individual's identification, he was a registered sex offender, but because state parks are not on this list and because our parks are a public place, we had no recourse to act. So this would provide that. There have been instances in other states. Tennessee has a prohibition on this. They recently arrested an individual for sex trafficking. The reason they started the investigation was because he was a sex offender in a Tennessee state park in violation of that code.
Senator Deeds.
Was the person who was loitering in a bathhouse a sex offender who had offended against children? Was he doing anything that was in violation of the law while he was just loitering? Wasn't there another remedy for you?
I believe we got a suspicious person call. I don't know if he was convicted of one of these particular actions, and I think that's an important distinction of the bill, that these are individuals who have been convicted of a sex crime against a minor. I would also say that we have drafted this to try to narrowly tailor it to match the local provision so that they are prohibited from going to areas where they know or should know that a child is present for the purpose of meeting that child. So we have tried to tailor this as narrowly as possible to provide protection. The bottom line is I've got 75,000 acres of land and 8 million guests and 100 law enforcement officers to cover that, and unfortunately some people use that space to do bad things.
Mr. Chair,
Senator Deeds.
that was my concern. The state parks are generally a lot larger than city parks or local parks. Would you see this bill as prohibiting a person from going near a state park or going near a facility in a state park where children are going to be present, or playground, for example?
I would say if they are an individual in this class who is going to one of those places to have contact with a minor that is not in their custody, then they would be in violation. I would defer to the Commonwealth's attorney on how that gets enforced. We have tried to draft this to not prohibit them from being in a park in its entirety. I think from an enforcement perspective, this is something that we would view as a tool in the toolkit if an instance like that individual who was loitering in the park, or if we saw someone with a child in distress or some other suspicious activity that caused concern, this would give us some recourse where we don't really have a lot right now.
Mr. Wells, let me tell you, here's my concern. Like the existing language in the code, to me, it affiliates the notice with areas which are very likely to have kids. And you have playground, athletic facility, or gymnasium. So it's the existing language is if the person knows or should know is a playground, athletic field, facility, or gymnasium. But and it's similar here. Plenty place locality is operated that they know is a playground, athletic field, facility, or gymnasium. But the language of state parks, it says any area of a state park, a lot vaguer than the specific places where you know kids are, where somebody knows or has reason to know that children are present. And I take my kids hiking. I mean, a lot of kids hike on trails. How does somebody know or have reason to know there's likely to be kids on the trail when they go on the trail? You can go on the trail sometimes, but you can't go on other times. It's not clear to me how you can provide somebody with the proper level of notice to ensure they're not going to get charged with a Class 6 felony when kids sometimes are there and sometimes they're not there. And so I appreciate the concern, but I don't know how somebody's supposed to govern their life other than just stay away from the park. the way it's worded. Playgrounds are clear, gyms are clear, athletic fields are clear. So, I mean, how does somebody figure that out? I mean, how does even the police officer figure out whether the person knew or should have known whether they should have been on the athletic trail or on that rock fishing or something? Like,
And Mr. Chairman, I would say that we drafted it in the way that we did to try to accommodate for the various natures of our state parks and the different areas. If it's something that would give the committee greater comfort and provided the patrons okay with perhaps having a more specific list, I think that's something that we would be open to.
Mr. Chairman.
Senator Stewart.
That's what I was going to suggest. If that is your only concern, then just say designated areas. And the park can designate the areas where the sex offenders can't go.
Have a sign up?
They put up a sign, no sex offenders here.
Mr. Chairman, if there are specific areas that would give the committee more comfort, I think we're open to that. What we're trying to do at the end of the day is to provide the same level of protection at state parks that our children enjoy at local parks.
Okay. All right. Well, we got it clear on your intent. I think you've heard some of our concern. Why don't we? I don't think we need 5 minutes on this. Maybe 2 and 2. Support and opposition.
If there's anyone online that would like to speak in favor, please
Is anybody
raise
else
your
in
hand.
support? Senator Diggs, do you know?
We support the bill. I don't think I said that. But.
Got it. I'm clear about that. Yeah. Nobody online?
Mr. Chair, there's one person that would like to speak. Andy, please unmute and
In
make sure your
favor?
camera's on.
In favor?
No, I'm speaking in opposition. This is Andy Eldridge, Justice for Virginia.
Right. Okay. Is there anybody opposed to the bill as present?
Hello, my name is Maisie Osteen. I'm with the Legal Aid Justice Center. We have concerns that this bill is just far too broad. I currently have worked with some folks who are on the registry for crimes against minors, which is all looped in together. When there's no actual sexual allegations, there's no interlap, but because of the charge that it's under, this would still extend to them. And I personally find a lot of respite and meditation in the state parks as an adult, and I think it would be a real travesty to take that away from folks that in this situation doesn't make sense for public safety. Thank you all.
Okay. Nobody else in person? Can we go to Mr. Elders online?
Yes, good afternoon. I'm here to speak in opposition. I'm from Justice for Virginia. I'm also a public defender in Fairfax County. Here are my concerns. The first is that this prohibition is permanent. It's another example of a policy directed toward people who have served sentences, probably prison sentences for these offenses, have completed very intense probation requirements. The system places these people under extraordinary scrutiny, and they should not continue to be punished once their sentence and probation are complete. The second is that it's duplicative. We know contact with children is already limited for probationers, especially. Probation is a case-by-case exercise ordered by judges and supervised by probation officers. If there's a reason for a particular person to be barred from certain areas of state parks, then courts can order those restrictions. They can also order that they not be in state parks altogether. By definition, these people are additionally required to register as sex offenders. So blanket bans like these are pointlessly redundant. I do not agree that this is narrowly tailored. I think the language is quite broad and will apply very generally to people who often, as Senator Servo noted, will not even know whether or not they're allowed to be in certain areas of the parks. The third is that this is overbroad. That is, state parks are often very large, as Senator Teeds noted. There's no reason that people with convictions can't enjoy these spaces without coming into contact with other children. There's no demonstrated link between state parks and sex offender recidivism.
Right. Mr. Elders, can you wrap up? The time's expired.
Yes. Finally, I just want to note that a lot of the people who are convicted of these offenses are themselves previous victims of prior sex offenses. They're trauma survivors, and a lot of them, it's pointlessly cruel to limit them from these public spaces.
All right. Thank you. Thank you, Mr. Elders. Okay. Is there any further discussion from the committee? Senator Peake.
I think the fact that we have an individual here talking about this happened at a state park where a sex offender was hanging out at the facility and there were complaints about it tells us that there's a need for this bill. The fact that pedophiles are the least likely to be reformed of any of our criminal offenders, and it's just been proven time and time again they're the most likely to reoffend. And this bill says if they are going where they know children are, meaning they can see them, or a playground or hanging out, I think we need to protect our citizens, and I think it's a good bill.
Is there any further discussion? No further discussion. Senator Stewart, you want to make a motion to put up a sign?
No, I listened to the gentleman from Fairfax, and I heard him say that this would be traumatizing to the sex offenders. And I'm worried about traumatizing these children that could be predated on by sex offenders, and this is a very reasonable measure. I mean, our society says if you commit crimes like this, you got to stay away from children. It's not a complicated issue. It's not an unreasonable issue. And state parks are full of young children camping and playing. And I think we should support this bill and not worry about traumatizing the person that committed the crime. Let's worry about the children instead.
Yeah, question for counsel. Mr. Benjamin, wouldn't you agree that in most situations where people are convicted of crimes against children, their terms of probation require they stay away from children, and the existing law kind of requires that usually?
Mr. Chairman, yes.
Right. Okay. Anybody else have anything to say? Senator Perry, it looks like you're leaning into your mic.
Yes, Mr. Chairman. I just have a question. The statement, and I don't have my line item up, but Part D that's added, it just says, for the purpose, like you can't go, every adult who is convicted of an offense prohibiting proximity to children when the offense occurred on or after July 21, 2024, shall, as part of a sentence, be forever as part of his sentence. I'm confused. If he's not, if he doesn't have a suspended sentence anymore, does this prohibition not apply to him anymore? He would still potentially, he or she would still be on the sex offender registry, right? So I don't really understand the language there as it relates to that. Is this only while they're under their sentence? 2, it says, for the purpose of having any contact whatsoever with children who are not in his custody within 100 feet, blah, 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 talks about the state park. I mean, if you are a convicted sex offender and on the registry, you're not supposed to be going places to have contact with children who are not in your custody anyway. So I'm not sure what the state park nexus has to do with anything. Can you answer any of those questions?
Certainly, the purpose of this bill was to protect our children. They're protected in local parks, and this bill has stood the test of time. We just want to extend that protection to our state parks, not let this be a loophole where we felt like it was just a place that was overlooked when the code was initially written.
And Mr. Chairman, Senator Diggs, I appreciate the intent of it. I quite frankly don't think the language captures quite what you're trying to do here.
Okay. It's been moved and seconded to be reported.
Mr. Chairman?
Yeah.
Actually, speaking to the bill, some of the things that concern me is one of the issues that were brought up is that the person was seen, he was there, he was loitering. There was no testimony that this was a person who was actively preying against children, that he was trying to entice children, that he was trying to do something to children at the time. And it wasn't until after the fact he was found to be loitering, then it was discovered that he was a registered sex offender. So I fail to see, it feels like this is a solution looking for a problem at this point. As Senator Perry just mentioned, and Chairman, that there are laws on the books, there are conditions that sex offenders already have to follow, saying that they cannot be in the proximity, they cannot be with children that's not in their care and custody. So I'll be voting in the negative for this for that reason. This is redundant, it's not needed. I think it's overly broad. And again, there is no example in Virginia actively to prohibit what you're trying to say happened, which wasn't someone who was in a state park trying to cause harm to a child, but who was in fact loitering. So I will be voting no.
Probably depends on the motion, Senator Kilfoy. So it's been moved and reported that moved and seconded the bill be reported. It has to go to finance and there's a substitute motion. Been moved and seconded the bill be PBI'd. Any further discussion? Clerk will open the roll.
Ayes 9, no 6.
All right, Senator Diggs, you sure you didn't arrange for that bill number, right?
Yeah, that could have been part of the problem.
Okay. All right, Senator Diggs, why don't we do your other bill that has not been, 208 we didn't actually discuss, did we?
Yes, I have an amendment. It's just a couple words there to make, to alleviate some concerns.
Okay, hold on a sec. Let me get 208. Oh. All right, 208, and we got amendments. 588, 633, 236, 207, and 2. I got it here. All right, Senator Diggs, just remind everybody to orient us. Where are we here? We're about confidentiality of juvenile court records.
Yes, sir.
Okay.
So essentially, this bill does two things. It provides the release of confidential juvenile records to law enforcement officers, and there was the amendment further specifies that this can only be done in the course of a criminal investigation. Part 2 of this provides for notification of victims of a release of juvenile from custody. So that's already something that's done routinely when adults are released from custody, but this section, as it exists, prohibited that, and we are just trying to protect the rights of victims and give them proper notice of a release of a juvenile from custody.
Okay, Senator Diggs, you have this amendment you put in front of us here. Can you explain your amendment?
I'm sorry, Mr.
Could
Chairman.
you just explain your amendment?
Oh, the amendment added the phrase that the confidential juvenile information would only be released to law enforcement in the course, and this is the amendment, in the course of a criminal investigation, as opposed to someone just being curious and calling and asking for the information.
Okay, is there a motion that we adopt his amendment? And moved and seconded, we adopt the amendment. All those in favor say aye. Aye. Anybody oppose the amendment? Okay, now we have the bill before us is amended. We took testimony in this bill last time, right?
I believe so, yes, sir.
Did we ever get to the point where did public testimony? We just talked about it.
I don't remember.
I don't remember either. I don't think we took public testimony. I don't think it ever got that far. So why don't we do, let's go 5 and 5 on this, MJ, and why don't we go all those in favor?
If anyone online would like to speak in favor, please raise your hand.
Mr. Chairman, Robert Tracy with the Office of Attorney General. We support the bill as amended. Thank you.
Thank you, Mr. Tracy. Mr. Bell, right?
Yes, Mr. Bell, Anton Bell, Mr. Chairman, with the Commonwealth Attorneys Association, we support the bill. The law currently does not allow most people to access social, medical, psychological reports or records of juveniles who've been referred to the courts, though there are a small number of exemptions, and Commonwealth attorneys, of course, are part of that exemption. What this bill would do is add 2 additional groups to have access. One is law enforcement, who have a need to access the juvenile's record when there is a criminal investigation taking place. And as we all know, some of the crimes that we deal with now are the perpetrators of those crimes are getting younger and younger. So that information is going to be extremely vital in being able to have a successful adjudication of who is doing those particular acts. And then also the victims who need that juvenile information for notification of release. And for those reasons, we are asking for this committee to pass this bill.
So, Mr. Bell, I got a question for you. So, Right now, you said the Commonwealth attorneys are allowed to request this, right?
That is correct.
So today, if there was a criminal investigation going on, I mean, couldn't a law enforcement officer call up your office and say, or, come within the state and say, hey, we'd like to look at this. Can you request it to help us make a decision?
That is correct, Your Honor. I was about to call you, Your Honor. I'm thinking I'm in court.
You were probably in court yesterday.
That is correct, Chairperson. However, here's the problem. Whenever you are in the midst of an investigation, we all know time is of the essence. And so sometimes you may not be able to get someone in order to be able to get that information, particularly in your rural jurisdictions, where you may have just one prosecutor in that particular jurisdiction. So for the bigger jurisdictions like Hampton, where you have multiple assistants, that may be helpful. But in those rural jurisdictions where you may have just one prosecutor or sometimes just one and another person, that may cause law enforcement to potentially lose ground or leverage in being able to conclude if that person is the individual who did this crime or the person is not the person who committed that crime. So time sometimes is really of the essence.
Mr. Bill, would you agree that sometimes having an attorney as a gatekeeper of a process helps to ensure sort of better decisions are made?
Absolutely. But in my office, we have a person who is actually connected to law enforcement where they're stationed there in order to help do those things. But we have the ability to do that. Again, in your rural jurisdictions, you do not have that access, you do not have that resource, and unfortunately, you don't have that funding. So most of our Commonwealth attorneys are small offices. Most of those jurisdictions are small rural jurisdictions, and as such, those are the areas that they're going to suffer the most because they're not going to have the ability to always put their hands on an attorney or the Commonwealth attorney to be able to get access to those records. And in those cases, again, time is of the essence, and unfortunately, justice may be delayed as a result of that.
Okay. Thanks for answering my questions.
Thank you.
Is anybody else in favor of the bill?
Mr. Chair, there is no one online to speak.
Okay, good. Ms. Schrad.
Good afternoon, Mr. Chairman, members of the committee. I'm Dana Schrod on behalf of the Virginia Association of Chiefs. I can't improve on the comments from the prosecutor. I previously served as the chairman of the Board of Juvenile Justice. We came across these issues, and we very much support the bill from the perspective of the police chiefs. So thank you.
Thank you. Anybody else in favor? Okay, those opposed to the bill, please come on up to the microphone.
If anyone online would like to speak in opposition, please raise your hand.
Legal Aid Justice Center, right? Yeah.
Good afternoon, Chair, members of the committee. My name is Abby Phillips. I work for the Legal Aid Justice Center. We are opposed to this bill. The proposed changes will minimize the standards for confidentiality protections for youth in treatment in the juvenile justice system, and frankly, their families, based on the language that is included in this bill. It also, I will point out, says anyone employed part-time or full-time by local or state law enforcement, which could actually extend beyond a law enforcement officer. These records are for children and youth that we have decided as a society need to support and to get back on track. Rehabilitation is a guiding principle of the juvenile system, and that is why these juvenile records are so carefully protected. And we ask that you please continue to protect these records. Thank you.
Okay. Next up.
Monica Hutchinson with Rise for Youth, and for all of the reasons that were just mentioned, we also oppose this bill. We must protect children and youth and not exploit them. Thank you.
Is there anybody online?
Mr. Chair, there's one person online. Andy, you may unmute and please make sure your camera's on.
All right, Mr. Elders, you have 3 minutes and 39 seconds.
I'll use less than that this time, Mr. Chair. I would just want to stress how limited the limitation that we just added to this bill is. To tell a police officer that all you have to do is say that you are in the middle of an investigation does not begin to approach the level of security that we add by having a judge stand between the police and a juvenile record. Judges are there for a reason. They're there to protect people's rights and ensure that For example, warrants go out under probable cause, and having the judge as a filter for requests like these is appropriate, and we should continue to leave that requirement in place. Thank you.
I think there's one more speaker online. Is that right?
Yes, Mr. Chair. Tayi, you may unmute, and please make sure your camera's on.
Good afternoon, Mr. Chairman. Tayi Mallory with the Virginia NAACP, and for the reasons stated, we also oppose the bill. Thank you.
Mr. Chair.
Okay, Senator Peake.
Yeah, speak briefly to the
I'm sorry,
bill.
it's really quick. There's nobody else to speak in opposition, right? Okay, yeah, Senator Peake.
Briefly to the bill, and actually talking about the last bill and speaking up here with Senator Stewart. I want everybody out there to pay attention to what's about to happen. We just voted against a bill to protect young people from convicted sex offenders, and now those same people are opposed to this bill on the grounds that they want to protect young people from police. Think about it when you see the vote.
Senator Peake, I don't think that's exactly what happened. I think there's some vague statutes that don't provide notice and would create a lot of ambiguity in the world. And I think with regard to this bill, there's concern about changing some longstanding policies. And I haven't really even heard any specific case or outcome that sort of necessitated this request, or any kind of prosecution or investigation went off the rails because these records weren't accessible at the time. And I think that's part of what the concern is from the folks who have spoken. Having said that, is there anybody have a motion?
Move to report.
Been moved and second. The bill be reported. Substitute motion, PBI. Is there a second? Second. Okay. There's been moved and seconded. We PBI the bill. All those in favor, or open the roll, please.
Ayes 9, no 6.
Thank you, Mr. Chairman.
Thank you. Senator Diggs, you have this one last one. I think you've done a lot of work on this next one, 207, universal licensure of law enforcement officers. You have a substitute, I believe?
Yes, sir. I have an amendment in the nature of a substitute.
Okay, Senator Deeds moves, and Senator Aird seconds the substitute. All those in favor say aye. Aye. Anybody opposed? Okay, the substitute's before you and being circulated. So Senator Deeds, Senator Diggs, I think this one has to do with sort of codifying an existing standard at DCJS about allowing other officers from out of state to be certified in Virginia. And last time I expressed concern about some of the standards we put in place in Virginia and whether we were going to be fully compliant with that. And you've gone back and done some work. So why don't you tell us what you've done?
Yes, sir. Thank you, Mr. Chairman. There's been, over several days, many edits to this to make sure that all the parties concerned are comfortable with the language. It's gone from just a few sentences to a decent-sized paragraph, and we believe that all of the issues have been addressed, and the goal of this bill is to certainly be able to recruit more law enforcement officers, those who were previously in law enforcement and those who came from other states as well. And I think we have some people who are in support of the bill.
Senator, can you tell us what's different between the last one and this one?
Yes, sir. There's many more code sections referenced to make sure that we are complying with DCJS standards, and it just clears up. It's a lot of different phrases in there that make people alleviated their concerns and to make sure that all the bases were covered.
Senator, I think Ms. May's offering to answer a little more concisely, right? Yeah.
Yes, Mr. Chair. I can point out what the differences are in the substitute. So the substitute would apply to law enforcement officers with at least 1 year of experience. The introduced bill was 3 years. It also specifies that the person must be in compliance with 15.2-1705 and 15.2-1706, which are the sections covering minimum qualifications and the minimum training standards. It also says that they have to have not had a break in service for more than 24 months. The introduced bill was 3 years, and specifies they must have left the agency in good standing, and there's no pending investigation or disciplinary actions. That language about pending investigations was not in the introduced bill. Also specifies the hiring agency has to be in compliance with that subsection B of 15.2.17.05, which is the section that requires them to request various information from the prior employing agency, including arrests, prosecution, civil suits, and various other information. And it specifies that the hiring agency shall employ all reasonable means to obtain the personnel records for the transferring officer. And then it also specifies that the law enforcement officer may be granted an exemption from certain training requirements, which is under current law, or that they may be still subject to the compulsory training standards.
Okay. Senator Diggs, I agree that that improves the bill. I still have a question and a lingering concern that you probably can't answer, but maybe somebody else can. But let me articulate it for you. So when we did the Police Reform Act in 2020, one of the problems that law enforcement leadership articulated to us was that officers, when somebody wanted to get hired by a different law enforcement agency, the agency they were leaving, or their former agency, former sheriff's office, former police department, would not share a personnel file with them or disciplinary records. And so one of the changes we made in the code back then was we required every Virginia law enforcement agency to share every scrap of paper they had about one of their employees with the new entity hiring them, so that the new agency hiring them knew they weren't getting a bad apple. And when you're talking about out-of-state departments, one of the concerns, at least I had, was that out-of-state departments might not be as forthcoming producing records about an officer who's had a history of problems. And this bill, the way it's written, as I read it right now, I'm sorry, I just looked at it right now, all it says is that you have to do a hiring agency shall employ all reasonable means to obtain records, which doesn't mean they have to get a single piece of paper. It just means they have to send a letter or make a call or say, can you give me this stuff? But it doesn't say that they actually have to get anything to confirm this officer they're hiring. You know, it doesn't have a whole track history of beating people up or not following orders or the kinds of things that I'm sure you saw a lot of as a sheriff of your department for 2 decades. And so that to me sort of seems to me to kind of be an end run a little bit about some of the standards we passed. Do you have any thoughts about that, or ways we can ensure that, you know, we're not going to be hiring some of the worst officers from out of state? They're getting chased out of the department out of state and bringing them into Virginia.
No, Mr. Chairman, what this does, I think, is ensures and reinforces that all efforts should be made to obtain those records. And I know that me as a law enforcement agency head, should I not be able to obtain those records, would be a red flag, and that applicant would no longer be considered for a hire because I could not do a thorough and complete investigation.
But Senator Diggs, wouldn't you agree that if we put language in there that says if they don't get a complete file, then this person can't go through this process? Wouldn't that solve the problem?
If that makes Mr. Chairman feel better, I have no objection to that, because I think that's something everyone, all law enforcement executives would comply with, whether it's law or not.
Okay.
But maybe some of my colleagues may want to speak to that.
Okay. Does anybody see? It looks like Chief DeBoard is twitching back there to say something.
Mr. Chairman, committee, the VCP, I'm Chief Maggie DeBoer from Herndon. I represent the Virginia Chiefs. We support the substitute, and your concern about that particular piece, we cannot compel a chief law enforcement executive from another state to provide those files. What I would hate to see is that we would not consider a very qualified applicant because they wouldn't give us the full file. There's a lot of things that we can do. We do require, according to this, through those code sections that are cited, that that the applicant has to sign a waiver to allow us to ask and give us permission to look at those files. But we do run into problems at times with HR departments in different places from other agencies where they don't always give us full access. But it is up to us ultimately to do the best due diligence we can to bring qualified applicants here to the state. If we had somebody that wouldn't give us any information, I agree with the senator, we wouldn't even consider them. But sometimes we don't have control of what we get access to and what we do not.
But Chief, wouldn't you agree that if another department out of state did not provide a complete file, that wouldn't prohibit them from being an LEO and a law enforcement officer in Virginia? It would just mean they'd have to go through the regular training process instead of this expedited quickie process.
it would give us another option to do that. And that's why they say they may have a waiver, they may not. It's going to be up to what we can validate through their training files and through their experience to even see that. But what we also don't know is what we're getting. Is it a complete file or not? We have no way of knowing that we have that we have received everything when an agency turns over stuff. There could be stuff that they're hiding at any point in time, even within the state. We don't always know that. It's up to us to ask and to really bring to light anything that we may feel is missing from what we're being presented.
Okay. Does anybody else on the committee have any questions? Doesn't look like it. Senator, I can just, speaking for myself, I'd be a lot more comfortable if it had some language in there about that. And if they can't get a full file or something that's certified to them as a complete file, then the officer would have to go through the regular process and not this expedited process. Otherwise, we might be undoing some of the progress we made a couple years ago. But that's where I am. And I don't know if everybody else feels that way, but that's an amendment we could probably make on the floor and work it out in the next 3 days. This might even have to go to, this does this going to finance? No? No. I don't know if anybody else feels the same way I do, but that's kind of where I am. That makes sense. All right. Senator Dietz thinks it makes sense. I see any nods down there. Okay. So I think you need to work with me or might have some issues on the floor. All right. So there's been a motion to report. Say what? Oh, we already did testimony. Didn't we do testimony last time? Did we? Do you remember, Senator Diggs?
I'm sorry. Would not want to be mistaken.
All right. Well, the bill seems to maybe be okay. Does anybody want to testify in favor of the bill and change our minds? Is anybody online?
If you're for the bill.
If anyone online would like to speak for this bill, please raise your hand.
Are you opposed? All right. You're in favor?
Yes.
Can you be quick?
Yes. Mr. Chairman, members of the committee, my name is Julia Gunderson. I'm with the Virginia State Police, and we support this bill.
Okay, thanks. Anybody opposed? Anybody online opposed?
Move to report.
We're getting there.
Substitute.
It's moved and seconded that we report the substitute subject to my amendment later. All those in favor say aye. Open the roll.
Ayes 15, no 0.
Thank you, Mr. Chairman.
All right, you got one. Who's next? Senator McGuire. Senator McGuire, you've got 559, and that's it, right?
That's it.
Okay, Senate Bill 559.
All right, Mr. Chairman, members of the committee, this is a anti- or human trafficking bill, and I think everybody here would agree that human trafficking is modern-day slavery. And so I'm here to discuss this bill that protects Virginians from this egregious and heinous crime, Senate Bill 559. This human trafficking bill aims to deter all forms of human trafficking in our Commonwealth by increasing the penalty for the crime. Most importantly, it protects our most valuable individuals, our youth. Protections include increased penalties for children, forced labor, or services, or child sex trafficking. Talking points, cases not involving minors increased to Class 3 felonies, punishable to no less than 5 years to no more than 20 years in prison and up to $100,000 in fines. Cases involving minors increased to Class 2 felony, punishable by imprisonment for life or nothing less than 20-year prison sentence, up to $100,000 in fines. And it was reported in 2021, 583 human trafficking cases in Virginia. 199 of those reports were made from victims and survivors. That number continues to increase due to Biden's open border policies and weak penalties that in no way deters human trafficking here in the Commonwealth. So with that, I've got some folks that will speak on behalf of this, and I hope you guys will pass the bill.
Okay, so Senator McGuire, right now, Class 4 felony has a term of 2 to 10. Class 3 is 5 to 20. Why is it you think going from 2 to 10 to 5 to 20 is going to cause less crime? Or deter somebody that wants to commit a human trafficking offense?
Well, I'm hoping that if we stiffen the penalty, it will there'll be less incentive to do it, maybe. People would be less likely.
Okay. Okay, is there anybody in favor of the bill? Let's go. Can we go to, let's go 5 and 5, I guess.
If there's anyone online that would like to speak in favor, please.
Hold on a
raise your hand.
second. We had a rule that says that your brother can't, the brothers can't testify for brothers. I don't, like.
I trust him, he's good.
Thank you, Mr. Chairman.
All right, we'll waive it this time.
Thank you for waiving it, Mr. Chairman. Rusty McGuire, Louisa Commonwealth's attorney. As you all know, that come here before talking about these cases where children are exploited and also with adults. This is not just a huge problem across the world right now. Some of you've probably seen the movie recently that was out talking about how children and women are captured in their countries and taken around the world for sex trafficking. It occurs in my county, it occurs in your city or county, it occurs around the globe. They're also very difficult to investigate and prosecute because the people that run these organizations know how to obfuscate their IP addresses on the internet. They use burner phones. They're really difficult. And so the other problem becomes when we do actually find victims and rescue them, they often have difficult times coming forward because they're often addicted to drugs. They're also rely on the trafficker for financial means. So because of that, it's difficult to make these cases. I do believe that increasing the penalty can have a deterrence effect. There might be a philosophical difference between some of us in that, but I think this is reasonable, more aligned with federal law, and it just gives that tool. Now, as association, I'm not here speaking as the association. I'm here speaking as Louisa Commonwealth's attorney. We don't take positions as an association about penalties. That's for the prerogative for the legislator, but I'm telling from the need of Louisa County. And why I'm so convinced of this is a case I had about 2-3 years ago now where a child was trafficked by her own father. He gave her meth, heroin, addicted to those drugs. He would videotape the heinous acts that he did to her. And the worst part is when the sheriff's office came and rescued this child, she was crying that her boyfriend was being taken away from her. That's the world we live in. It's sad. It's sick. Nobody ever wants to see that. But that's the world, and we need to send a message that traffickers are not welcome in Virginia, and thank you for your time.
Thank you, Mr. McGuire. Anybody else in favor of the bill? Okay, is there anybody online?
Mr. Chair, there's no one online to speak in favor.
Okay, is there anybody opposed to the bill?
If anyone online would like to speak in opposition, please raise your hand.
Anybody in person opposed? Nobody. Okay, Senator McGuire, just note, we talked about Class 4 to Class 3 felony, but I would also note that this also takes some stuff from Class 3 to Class 2 felonies as well, which is, I think Class 2 felony is like, what, 10 to life or 20 to life? 20 to life. Okay. Well, you're all by yourself over there.
I need some reinforcements over there.
Yeah. Okay. Is there a motion on the bill? And it needs to go to finance. Okay. And somebody over there with you seconds? Okay. It's been moved and seconded. The bill be reported. Is there a substitute motion? Substitute motion to what? To PBI, and it's got a second. Seconded by Senator Salim. Clerk will open the roll. You got Stanley?
Ayes 9, noes 5.
Okay, got it. All right. Senator McGuire, your bill is PBI.
Thank you.
Yeah, thank you. Okay, next up we have Ms. Reeves. You wanted to go at the end. You want to go now? You ready to go? Okay, Senator Reeves brings back a bill we saw last year, Senate Bill 7. It's identical, close?
Mr. Chairman, in agreement with Senator Suthar, I understood that I have an amendment that's going to make mine like the senator's bill.
So I think what you're saying is you would like to incorporate 120 into 7, but conform 7 to 120. Is that right? It's been moved. We do the conformity second, so the incorporation's recorded, the other one's as a voice. So why don't we...
Unless the three of us are chief co-patrons.
Hold on, there's been motion and second to incorporate 120 into 7 and to make Senators Subramaniam and Bagby chief co-patrons, or chief patrons, if possible, of Senate Bill 7.
That's correct.
Been moved and seconded. Clerk will open the roll.
And Mr. Chair, if we could hear from council real quick.
We're getting there. Hold on. What? Okay, and you wanted to conform, right?
Senator Peake for.
Peake, you and Jordan, you guys. Okay.
Ayes 14, no zero.
Got it. Senator Reeves, we need to conform now.
It's conformed now, but I'm going to have council go through because
it's
I
not-
don't have a.
It's not conformed yet. So I think Senator Subramanian moves and Senator Foy seconds, conforming Senate Bill 7 to 120. All those in favor say aye. Aye. Anybody opposed? No. So now 7 is equivalent to 120.
And Mr. Chair, if I could just clarify, they were identical as introduced, but I believe there's some amendments that were going to be proposed on SB 120, but since they're now incorporated, should probably be proposed for SB 7. We can pass out the substitute as it would have been for Senate Bill 120, just so everyone can see the amendments, and I will post them online under Senate Bill 120, just for anyone watching to see. But basically, the amendments, the bills as introduced already amend 2 sections in the Virginia Human Rights Act, the Declaration of Policy section and the section on construction of the chapter. So the substitute adds 2 additional code sections also within the Virginia Human Rights Act, 2.2-3904 and 2.2-3905. So it adds ethnic origin in several places where the same list of protected classes are listed throughout those 2 code sections, just to keep it consistent within the Virginia Human Rights Act. And those 2 sections cover the causes of action for discrimination in employment and in places of public accommodation.
Okay, thanks. So it's been moved and seconded that we adopt the substitute that was proposed for 120, but now is for Senate Bill 7. Senator Subramanian moves, Senator Foy seconds. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay. Now, Ms. May, is this bill, how identical is this to the bill we passed last session?
Mr. Chair, as introduced, it was identical. It's only those 2 new code sections added in the substitute, which I just explained, that would be different from last year.
Senator Reeves.
Mr. Chairman, I think my understanding in consultation with council, because I was worried about that, was these are more technical in nature than transformative in nature. Would that be true, council?
Mr. Chair, I think they would be viewed as technical to keep the list of protected classes consistent throughout that Virginia Human Rights Act, but the bill already adds ethnic origin to the Declaration of Policy, and these 2 sections are more about laying out the actual causes of action that could be brought by an aggrieved person, or in some cases, the Attorney General.
Okay. So we now have the bill as amended. I don't think we've taken any testimony on this at all yet, right? Senator Reeves, anything else you want to say?
I don't think we've taken any testimony this year on it.
I got it. This bill passed this committee 15-0, the Senate 39-0, minus the 2 things we just added. But I think we still need to take testimony and see if there is any. Does anybody want to testify in favor of the bill?
If anyone online would like to speak in favor, please raise your hand.
Remember, we heard this bill last year. So
I'll be quick.
it's looking pretty good. Yeah, 5 and 5, please.
Okay. Good afternoon. My name is Amy Melnick-Scharf. I'm a volunteer with the chair of the Legislative Committee for the Jewish Federation of Richmond. I'm here today on behalf of several Jewish federations throughout the Commonwealth. I'm honored to speak in support of this legislation. Thank you for the Senate lead patrons, including my own Senator Bagby, Senators Subramanian and Reeves, for introducing this bipartisan legislation to amend the hate crime statute. The bill, when passed, will safeguard all individuals within the Commonwealth from unlawful discrimination in employment in public because of one's ethnicity. For new members of the committee, as you said, it passed unanimously last year, and the House also passed overwhelmingly a slightly different bill, and the session ended without achieving a compromise. The legislation adds the words ethnic to the list of protected classes, which of course also includes race, religion, gender, sexual orientation, and national origin. Ethnicity is a collective identity which often includes the belief in a common history and origin and may include shared traditions, language, and religion. Examples include Han Chinese, Zulu, Kurds, Basque, and the Jewish people and community of which I am a part. It's essential to note that the perception and definition of ethnicity can vary widely among different societies and individuals. even among the ethnicity. As a Jewish person, this is my religion, but it is also my ethnicity. There are many Jews who don't look like me, Jews of color, who speak a variety of languages and who do not even practice the religion at all, or who practice it very differently. However, we are all ethnically Jewish. While this legislation is not about any single community, nor does it name any specific community, and nor should it, this bill will ensure that all Jewish individuals are included in Virginia's laws against discrimination and assault, regardless of whether they identify or are targeted based on Judaism's religious or ethnic aspects. Thank you for your support of SB 7 and SB 120. Thank you.
Thank you. 3 minutes to go.
Mr. Chairman, I'm Rabbi Eric Fussfield of B'nai B'rith International. I'm an Arlington resident and a former member of the Virginia Commission to Combat Anti-Semitism. We are witnessing an explosion of anti-Semitism in our time. And one of the keys to combating this problem has always been to increase understanding of what exactly anti-Semitism is. According to FBI statistics, Jews are by far the most targeted group among religious groups for hate crimes. But Jews are not merely a religious group, they are also an ethnic group, and by virtue of their shared national origin are a protected class under Title VI of the Civil Rights Act of 1964. Anti-Semitism is not primarily a religious freedom issue, it's a human rights issue. This bill would help properly identify crimes with anti-Semitic intent as hate crimes or instances of discrimination with anti-Semitic intent as discrimination. It will not curb free speech. It will help address anti-Semitism. I thank the sponsors for introducing the bill, and I urge the committee to support the bill. Thank you.
Thank you for coming. Next up.
Good afternoon. Thank you. My name is Richard Samet. I am here on behalf of not only the Jewish Community Federation of Richmond, but also on behalf of Sam Asher, who is the executive director of the Virginia Holocaust Museum. And I don't want to repeat some of the points that were already made about Judaism being not just a religion, but also a cultural and ethnic identity. There are several hate groups that do not even view Jews as a religion, but as an ethnic group, as a bloodline and so forth. Sam Asher wanted to express his deep concern regarding the alarming rise in hate crimes across the Commonwealth and nationally. And we all know, we've heard testimony already about the explosion in anti-Semitism over the past few months, but it's important to note that the hate crimes against the Jewish people is part of a broader dramatic increase in hate crimes experienced across all communities. This bill, by simply adding ethnic to these definitions, will cover more than just the Jewish community. It will help the enforcement agencies and so forth in the Commonwealth make sure that all people are given the full extent of protection of the law. Thank you.
Welcome. We got 24 seconds.
Mr. Chairman, my name is Karen Leibowitz. I'm here with the Jewish Federation of Richmond. I'm a member of their legislative subcommittee, and I wanted to express my support for this bill. Thank you.
Thank you.
I'll keep it quick, sir. Mr. Chairman and committee members, my name is Jonathan Schleffer, Deputy Secretary of Public Safety. The administration supports this bill.
Thank you. All right. Anybody online?
Mr. Chair, there is no one online to speak in favor.
Wow, what difference a year makes. Okay. Anybody opposed?
If there's anyone online that would like to speak in opposition, please raise your hand.
Welcome. Good to see you again.
Okay, so we have a total of 5 minutes then?
5 minutes.
Okay. My name is...
You might not help
you.
yourself taking all 5,
Thank
but
you.
so
No,
let's
I
see what
won't
you
take
say.
it all. My name is Nancy Ween. I'm a Jewish human rights activist. I think people know that about me. We, in the Virginia Coalition for Human Rights, we believe that these hate crime bills are going to pass the General Assembly this year. We're not surprised. However, we wish to go on record that we understand what's happening. Last year, Governor Youngkin and the Republicans pushed for the adoption of 2 hate crime bills, which they originally labeled as hate crimes and discrimination anti-Semitism penalties. They openly added anti-Semitism to the list of discrimination classified as a hate crime. In the final version of these bills, the title was unchanged, but strangely enough, in the body of the code, they removed the word anti-Semitism and replaced it with ethnic, and then the bills never got reconciled. Also last year, and most importantly, the General Assembly passed HB 1606, which defines anti-Semitism using the IHRA definition. This definition, with its examples, clearly says that those of us who criticize Israel, as a racist state are guilty of anti-Semitism. I am telling you, Israel is a racist state. Now, it is not just the right-wing white supremacist racists this says that it is not just the right-wing white supremacist racists who are anti-Semitic, and of course they are anti-Semitic. That's where anti-Semitism comes from, the right wing. They are already targeted by the hate crimes bill as it is currently written, and we don't need this. These people are true threats to Jews. Their rhetoric and actions are truly anti-Semitic and hateful. But those of us who are human rights activists are not expressing hatred at all, but rather we are showing love and concern for all humanity and supporting everyone's right for equality and justice. And I stand for equality and justice. I think I'm going to close and let someone else take over from here. But we are not racist and we're not anti-Semitic. We just do not like what Israel is doing. Thank you.
Thank you.
Mr. Chair, there is one person online, Zena Hutchinson. You may unmute and please make sure your camera's on.
Welcome, Ms. Hutchinson. Good to see you.
Hey, nice to see you. Thank you. Can you hear me? Am I good?
Yeah, we can hear you. Make sure your camera's on.
Okay. Okay, great. You can see me too? Okay, great. I'm here to oppose this bill, or these combined bills. To oppose the addition of ethnicity into the hate crimes statute, which may seem odd, but to those of us who are the target of such underhanded attempts at censorship and attacks by those pushing multiple legislation, it is quite clear. We have followed the progression of these amendments since last year, and just like we tried to warn you last year that passing the extremely controversial and problematic IHRA definition is a mistake, we are here to raise the alarm bells again. This is not what it seems to be. Yesterday in the House General Laws Subcommittee meeting, Delegate Simon voted against the anti-boycott bill, saying that it was not a good solution to fight against anti-Semitism. Instead, he said that these new hate crimes bills are a better tool to address the issue of anti-Semitism. I thought this was about ethnicity in general. Interesting. Unlike last year's failed attempts, these amendments are carefully crafted to avoid the words anti-Semitism entirely, at least at this point. And as we know, due to the IHRA bill now in Virginia Code, the definition outrageously includes criticism of the Israeli regime and support for Palestinian rights. We were told last year by some of you, quote, not to worry because the IHRA definition is, quote, non-binding. Yet this and in other bills, we see an attempt to criminalize criticism of a foreign government. We understand the power that it is working behind the scenes to introduce and push these bills through and the reasons why they're being carried. We elect representatives to protect us and our rights, but we, particularly on university campuses and university and school campuses, are being targeted. We feel unsafe. Attorneys are aware and will be diligently protecting Virginians who will continue to speak out against the outrageous policies of the apartheid Zionist Israeli regime that is currently engaged in genocide and ethnic cleansing. Let's get foreign governments and their lobby groups out of Virginia politics, please. Thank you for your time. Please vote no on these bills.
Thank you, Ms. Hutchinson. Okay, the time's expired for opposition. Is there any further discussion about the bill? No, let me just say that this, I guess this is the second round of this. We heard a lot of it last session, and we had a lot of people testify about 3 different bills, and this was the one bill that got out of the Senate that we thought reflected sort of a fair way to deal with the situation. The other bill that you just heard about, which was a different bill, had more conflict associated with it, but But I can tell you that my grandparents were some of the first Jews probably in Fairfax County, or at least some of the first in 1935, and they definitely, they and my father and even my kids have felt the difficulty associated with anti-Semitism, and I think this bill will make some progress in that direction. And I think there's an old saying that says, 2 Jews, 3 opinions. And I think that's not inaccurate here. But so in any event, that's the chair's view on the bill. Does anybody else have any discussion?
Yes, Mr. Chair.
Senator Carol Foy.
Mr. Chair, speaking to the bill, I just want to be very clear that I look at the letter of the law, the words on the 4 corners of the paper, and for this bill, what it does is that it adds ethnicity. Nothing more, nothing less. It is not overexpansive, it's not too broad. I believe what it does is modernize our code section, our discrimination code section, more in line with other states and the federal government, which I think is a good thing. So I understand that some people are questioning others' intent, whether or not this bill will morph into something else. But as is, this is something that I can agree with. Ethnicity is a group that shares a common and distinct shared culture, religion, language. That's what this is. And so when people are discriminating against other folks and hate crimes are happening based upon someone's ethnicity, as well as race, religion, color, then I do believe this should be added. It has a place. It modernizes our discrimination code. And as is, I can support. Thank you.
Okay, is there any further discussion about this bill? Senator Subramanian, you want to have the last word?
Yeah, Mr. Chair, I'd just say that I don't think she was able to join, but online we had someone from the Sikh community here to testify in favor of the bill. I think we have a growing Sikh community. We also have many other languages and ethnicities that don't identify with a religion or a nationality in our county and in Northern Virginia. That I think, as it is, it's hard enough to prosecute hate crimes, and the ambiguity of not having ethnicity here, I think, has been problematic. And so I think the intent here and the 4 corners here are to resolve that issue and protect people of different ethnicities. Thank you, Mr. Chair.
Thank you, Senator. Any other discussion? Okay, this bill needs to go to finance for reports. Is there any motion? It's been moved to report and re-refer the bill to finance. Any further discussion? The clerk will open the roll.
Ayes 14, no zero.
Thank you, MJ. All right. Next, I see in the queue Durant, Senator Durant. Although all I can think of now is Senator Duran.
I'm glad they didn't ask me any songs because I think I would have choked on it. So
I've been to a Duran concert, so I can sing some.
Now it's a thing. So
Thursday night. There you go.
all right. Thank you, Mr. Chairman.
Which bill do you have?
Members of the committee, Senate Bill 442.
442.
Yes.
Looking on my list here. Where is it? Okay. Computer trespass.
Yes, Mr. Chair, members of the committee, Senate Bill 442 will add to the code section elementary or secondary school or school boards as a felony, someone who violates the section affecting a computer exclusively, along with already in the code section, Commonwealth or local government or other department or agency thereof. So what this bill seeks to do is a ransomware attack, make it a class 6 felony to the code section for schools, school boards, et cetera, because it is likely affected across the country well over 5 million U.S. students by now, with district attacks on track to rise this year, according to cybersecurity firm Record Future. Nearly 1 in 3 U.S. districts have been breached by the end of 2021, and often strapped for cash. Districts are grossly ill-equipped not just to defend themselves, but to respond diligently and transparently when attacked, especially as they struggle to help kids catch up with the pandemic and grapple with shrinking budgets. That's according to an article that came out in the Richmond Times. There's no question, Mr. Chair, members of the committee, that this is not only incredibly expensive for school districts if they were to deal with this type of situation, but the compromised data that would affect our schools and disrupt their ability to continue to seek their education is really at the forefront of this concern. That disruption would affect students' access to their education and would compromise sensitive data and disrupt essential services within schools. Educational institutions should be a safe environment for learning, and attacks disrupt that fundamental right. Criminalizing computer trespassing against our schools and school boards will serve as a valuable deterrent and protect sensitive data and personal information. So I think it's worth noting that we already have in the code that it's a felony if it's against local government. And internet protocols, if it's interrupting our oil, gas, sewer, et cetera. So this is just adding our schools into that level of protection. It's the will of the body committee to pass, and happy to answer any questions.
Yeah, so Senator, is there what brought this to your attention? I mean, was there a specific situation? Did one of your localities ask you to bring this? I mean, why do we care about elementary, secondary schools? I mean, why is a class 6 felony versus a class 1 misdemeanor going to change anything? I'm trying to understand where this came from.
Yeah, thank you, Mr. Chair. We did I know there is one, Pulaski County Public Schools investigating a cyber attack, and there have been some others outside that I know that have been of significant note. Minneapolis, I think, had a school district that had a pretty significant attack. So this is really, I think, considering the consequences that our school districts could face, particularly for larger school districts like Fairfax County or even those in my district elsewhere. If they had that, we're just not equipped, I think, to deal with the financial repercussions of how to address it. So I think it is really important for the Commonwealth to get ahead of this instead of behind. I do also have some folks here that are here to testify and further support with it.
Okay, Senator Stewart has a question.
Well, I'm just trying to make this thing jive. So it looks like to me it's public infrastructure. It becomes a Class 6 felony, and I think it's a fair assumption that public schools, public infrastructure, and that's in that proper category.
That's correct, Mr. Chair, Senator Stewart. I mean,
isn't that true?
If you look on lines starting at line 32 and you step down to line 34, so it is a felony for those affecting the Commonwealth or local government within the Commonwealth or any department or agency thereof, a provider of telephone, wireless or voice over internet protocol, oil, electric, gas, sewer, wastewater, water service, and this would add elementary, secondary school, or school board to that list already existing in the code. So I think it's worth noting that we should not have a lesser penalty for our school districts or school boards, what we already have existing for the rest of those agencies.
Thank you, Senator. So one other question that's arisen is that you talk here on 37 about any elementary, secondary school board. School board's obviously public, because I don't think there is such a thing as a private school board, but does this apply to private elementary or secondary schools?
Yes.
Or what about high schools?
At secondary school, I believe that would encompass a high school.
Mr. Chair.
No, that's not how it works. Ms. May?
Mr. Chair, I will note that it links to that section 22.1-1, and in that section it says elementary and secondary includes elementary, middle, and high school grades. Just wanted to point out that it links to that definition.
Because Because I have one secondary school in my district and one high school, but I understood them to be different.
I think it may depend on how it's defined in the code, but since I think it may depend on how it's defined in the code, but since this bill says as those terms are defined in 22.1-1, and that
Right.
section says it includes high school.
Right, but Ms. May, that definition doesn't apply in this title, right?
It doesn't, but it's linked in the language of the bill. It says any elementary or secondary school or school board as those terms are defined in section 22.1-1.
I got it.
But I will note that if it is the patron's intent, or if it's the committee's intent that it apply to private schools or religious schools, it may help to add that language to clarify, because I'm not sure it's clear right now, but I guess it depends on what the committee would like.
Okay. Does anybody in the committee have any questions about this bill? Creating a new felony, or not creating a new felony, but elevating the penalty from Class 1 misdemeanor to Class 6 felony for this type of conduct? Nope. Okay. We'll take testimony. Is anybody in favor of the bill?
If anyone online wishes to speak in favor of the bill, please raise your hand now.
Yeah, 5 and 5, please. Thank you, Jay. AG.
Mr. Chairman, Robert Tracy from the AG's office. We support this bill. Thank you.
To the point. Nobody here from the School Boards Association to tell us their view on this bill that affects all their computers, essentially. No? Okay, great. Somebody's
There's no
coming
one
up.
online,
Hold
Mr.
on.
Chair.
Hold on, somebody's coming up.
Mr. Chairman.
Hi, Mr. Chairman. Lindsay Akers, also with the AG's office, but I wanted to say the Virginia Association of School Boards support this bill.
Okay, they told the AG to say that.
Mr.
Yeah?
Chair, there is
Okay.
no one.
All right.
There's no one online to speak to this bill in support.
All right, Senator Stewart, you have questions about support before we get to opposition?
I was going to ask the patron if she wanted to amend it to include
Why don't
private.
we do opposition first and get back to that? Anybody oppose to the bill?
If anyone online wishes to speak testimony to oppose the bill, please raise your hand now.
Nobody opposed. Okay, nobody's opposed. Senator Stewart.
Thank you, Mr. Chairman. Senator Durant, would you like to amend it to clarify that it would be applicable to private and religious primary and secondary schools too? Or the language that council used?
Yes, Mr. Chair, and I think that would be adding on line 37, just adding any public, private, or religious elementary or secondary school would clarify.
Would you like that?
I would.
I'd move that amendment, Mr. Chairman.
It moved and seconded that we add private schools to this, or make it clear this bill applies to private schools. All those in favor say aye. Anybody opposed? Anybody's opposed? Okay. Any further discussion? Nope. No further discussion. Okay. Oh, wait, Senator Durant, anything else you want to say?
No, thank you, Mr. Chair.
All right. So, when I was a kid, teachers didn't have computers back in my day.
I
But-
didn't have it either.
So if anybody wants to prank their teacher by looking at their teacher's email account, they're going to be looking at a felony now. So that's
That's not. Okay.
that's what it does. But it's been moved and seconded. I'm sorry. I think the bill needs to go to finance because it's got a felony. It's been moved and seconded. The bill go to finance. Clerk will open the roll. That's what it will do. It's already a misdemeanor. Clerk, open the roll. Yeah. Subramanian. There you go. Okay.
Ayes 15, no zero.
Off to finance.
Thank you, Mr. Chair. Thank you, members of the committee.
Yep. Children in Virginia are just beside themselves. Okay, can't prank their teacher anymore. Who's next? Senator Sturdivant, we have something for you here.
All right, thank you, Mr. Chair.
Convention.
Since the hour is late, I'll attempt to be brief.
5:15.
Yes, sir. Senate Bill 384.
You have two? You have two?
Pardon me?
Do you have two bills?
I do.
Okay, let's get caught up here. 384. Trying to find it on my. Oh, here. I'm sorry. Human smuggling. Got it. All right.
Yes. This is a different bill than what Senator McGuire had. So here is the issue, Mr. Chairman, members of the committee. The National Human Trafficking Hotline for Virginia got about 140 contacts for cases. I think it was in 2021 is the most recent data they have. I looked back, the years that they have, going back to 2018, it's about between 100 and 200 contacts a year. That's people who call the National Human Trafficking Hotline. The challenge is, if you look at the number of human trafficking cases that get prosecuted at the state and the federal level, it's very, very low. At the federal level, last year, I think there were only 4 human trafficking cases that were brought forward, and the year before that, it was something like 6. So there's a big delta between the number of human trafficking cases that are out there and the numbers that are getting prosecuted. And one of the challenges that we have in the Virginia Code is our human trafficking laws aren't great. They require you to either prove that the person is being trafficked for the purposes of prostitution or unlawful sex, or to be married against their will, or it requires you to prove that they're being trafficked for forced labor. And so what this bill attempts to do, I came across a Virginia prosecutor's human trafficking toolkit put out by the Human Trafficking Institute, and they noted that the hardest thing to prove in a human trafficking prosecution is the coercion aspect of it. And so what this bill seeks to do, Mr. Chairman, members of the committee, is to give another tool in the toolbox to our prosecutors to make it easier for them to bring cases when people are being trafficked, but without having to go that extra step of having to prove it is for forced labor or for prostitution. And so the language that I use in here is likely to be exploited for financial gain, because there are many more ways to exploit someone than just through prostitution or through forced labor. And so that's really the bulk of the bill, Mr. Chairman, and then it has elevated penalties if the Commonwealth's able to prove that it was a child that was being trafficked for financial exploitation, if there was serious bodily harm or death, and so it increases the punishment. But that's really where the genesis of this, Mr. Chairman, is. We got a lot of human trafficking reports, relatively speaking. We have very few prosecutions. The laws we have in the books can make it challenging for our prosecutors, and so that this bill seeks to provide another path.
Senator Sturban, am I correct that this is already illegal under federal law? It's just not a state law that parallels this?
Mr. Chairman, I'd have to look and see what the federal code says. I suspect it may only cover forced labor and prostitution, but admittedly I've not looked to see. But the challenge, as I mentioned, is that the number of prosecutions in Virginia under the federal law are in the single digits.
Right, it's up to DOJ, obviously. Senator, I had one other question. So your bill uses the language on line 13, and then it's just line 13. Unlawful pecuniary benefit. So it says any person who with the intent to obtain an unlawful pecuniary benefit. What's an unlawful pecuniary benefit?
It's a phrase, Mr. Chairman, to attempt to cover any pecuniary benefit, and to your point, perhaps unlawful is not the right word there.
It's probably not needed. It's probably not needed.
I think you're right.
Okay, since Senator Deeds moves and Senator Floyd seconds, removing unlawful from line 13. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay. Anybody have any other questions for Senator Sturban before we take testimony? Senator Stewart.
To someone, maybe Steve Benjamin, do we not typically insert a reasonableness standard when it comes to someone that should have known something. And so specifically on at the end of line 15, should we say that knows or reasonably should have known? And maybe I'm overthinking this, but I thought generally there is a reasonableness standard when someone should have known something.
There is, Mr. Chairman, Senator Stewart, but when we say should have known, that implies reasonably should have known.
So you don't need to put it in there?
I don't think so.
Okay.
Are there any other questions for Senator Sturtevant? I think there's some opposition to this bill out there as well. So do you have anybody in favor? Do we?
No, Mr. Chairman.
Got it. You were in court yesterday, too. Okay, why don't we go 5 and 5 just to be safe? And
Those online who wish to speak in favor of this bill online, please raise your hand now.
And turn on your camera. Nobody?
There's no speakers, Mr. Chairman.
Okay. Is there anybody opposed to the bill? Let's reset the timer. I have a note that says that the Commonwealth attorneys opposed the bill.
There's no speakers online, Mr. Chairman.
Oppose. I have a note that says that, although I assume they're here. Association of Commonwealth Attorneys, VACA, they here?
I've not been informed of that.
All right.
Mr. Chairman, Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, speaking on behalf of the Virginia Association of Commonwealth Attorneys. I apologize. I was doing something else. Did you say you had a note that we oppose this bill?
Yeah.
No, that is not. We do not oppose this bill.
All right. Maybe there's a different VACA. All right. Not hearing any opposition to this. All right. So it's been moved and seconded that we report.
Mr. Chairman, I don't know if you need critical comment or not, analytical critical comment. Because I'm just here to help.
Mr. Chairman, I'm happy to consult with Mr. Benjamin after the committee is over.
Yeah. All right. So it's been moved and seconded that we report and refer the bill to finance. Clerk will open the roll. We'll just.
Ayes 15, no zero.
Okay, Senator Sturtevant, you got one to.
Mr. Chairman, before the bill goes much further beyond this room, I'll just note that it does need a number of technical corrections.
Okay. Okay. We'll talk about it after the committee, okay? Senator Sturtevant, you have one other, right?
Yes, sir.
This is about conventions or. Oh, yeah, this is about electors or something, right? Okay. 528.
Yes, sir. Mr. Chairman, Senate Bill 528. I had a similar bill in P&E yesterday. If you've been in the General Assembly for any extended period of time, you've come across the Article 5 Convention of States efforts. This is an effort that I agree with, and it's to try to help rein in the federal government with term limits, and a balanced budget amendment is essentially the long and the short of it. If you've been lobbied on it or come across it before, you probably have a position. I think it's the right way to go. We do have an amendment in the nature of a substitute. The original draft had the references to an Article 5 convention in there. It just takes that out.
Okay, hold on. So Senator McDougall moves and Senator Stewart seconds your substitute. All in favor of adopting the new substitute, say aye. Aye. Anybody opposed? No. Okay, the substitute is before us.
Thank you. And so this bill is not the resolution to call the Convention of States to amend the Constitution. That has not been brought this year. So this is not what many of you have seen and voted on in prior General Assembly sessions. But some of the feedback that Convention of States folks have gotten is, well, how does this work when you select the delegates? What sort of parameters are in place for how the delegates are selected? And so that's essentially what this is putting in place a criminal penalty so that if and when we do get to the point of reaching 34 states that have passed this resolution, that We have shown up front how that delegate selection process happens or would be proposed to happen, and what the penalties would be for delegates that don't comply with the directives given to them by the General Assembly. And so this is sort of a effort at transparency and bringing to the attention of the body how this process would work to make sure that we have the necessary guardrails in place. And that's the bill, Mr. Chairman.
Thank you, sir. I have a question for council. I mean, doesn't this either take the penalties down from felony to misdemeanor or go after things that are already legal, like bribes? I mean, it says a bribe is now a Class 1 misdemeanor. That's already, I think, something that used to be a felony, wouldn't it? Why don't we while they think about that, why don't we take testimony in favor? Let's set 5 and 5.
Thank you.
Okay. Those online who wish to speak in favor of this bill, please raise your hand.
Okay, come on up.
Mr. Chairman, members of the committee, my name is Philip Whitaker. I'm here on behalf of this bill. The federal debt of the United States right now stands above $34 trillion. That's about $100,000 for every voter in the Commonwealth of Virginia. And that's only going to go higher, and that level of debt will become unsustainable for a free people. Members of the legislative and executive branches federally believe that government control of individual lives is their right and that they are superior to all other levels of government. The constitutional framers warned us that Congress would be unwilling to curtail their own power once they had it. Article 5 of the United States Constitution includes the prescribed remedy for these conditions, a convention of states to propose amendments. That mechanism is designed to help curtail the runaway Congress and federal spending and regulation. An Article 5 convention will happen at some point. And with a part-time legislature in Virginia, it is possible that the 34-state threshold could be met and Congress could appoint a time and place for the convention and the convention be held between legislative sessions in Virginia. If that were to occur, Virginia would have two choices. Either don't send a delegation to the convention or to have the governor call a special session to have the legislature issue the proper resolution to appoint and control those delegates. This bill at least adds the first step in that process and says when that convention happens, if it happens, then we have a penalty in place, even if nothing else other than the basic resolution to call for the convention happens, that there is a bill in place that says delegates to this convention have to obey the instructions of the General Assembly. It is you, ladies and gentlemen, who are in control of this process and of the delegates. And we want to be sure that those delegates, when they go to this convention, are obeying the instructions of the General Assembly. We ask you to support this bill.
My name is John Damon. I'm State Director for Convention of States out of Spotsylvania, Virginia. This is a question that we've heard among several legislatures throughout the United States. How will we control this? Who will control it? And under what manner we will control it? And it has always dumbfounded us that the people in the legislatures that were asking that question are the very people who would control this. So what we're doing here is we're saying that you have asked for this, for a bill to regulate who and under what manner that they would go to this convention, and we're asking you that you act on SB 528 and that you vote for it so that Virginia is ahead of that curve, because it's not a matter of if, but when. And we also say that when the states are working in unison, they are the most powerful government in the United States, and we're asking you to consider that as a convention approaches. Thank you for your time.
Hey, I got a question for you, Senator Sturtevant. So, I mean, wouldn't this basically make it a felony to, or well, I guess under your substitute, wouldn't it make it a crime to basically do what George Washington, John Hancock, all those guys that wrote our Constitution did? Because they weren't supposed to write a whole new Constitution. They were just supposed to make some amendments and tweaks, and it turned into a whole new document. So wouldn't this sort of make what they did a bunch of crimes?
Yeah. Could I refer to my expert witness on...
Yes. Yeah. Thank you, Mr. Chairman. The original Constitutional Convention of 1787, there were two, actually. There was one commission late 1786 that was to amend the Articles of Confederation. There was a separate commissioning after the December convention fell apart because the articles required all 13 states to be represented in order to pass anything, and they didn't have but 5 to show up. The 1787 convention was commissioned by the General Assemblies or the legislatures of the 13 colonies, and they all, or 13 states at that point, and they all but Rhode Island sent delegates. But each of those commissions stated clearly that they were there to develop a constitution or render a constitution sufficient to the exigencies of the Union. So no, it was not an offline convention. It was in accord with what their general assemblies and their legislatures had asked them to do.
Okay, I don't remember it that way, but I appreciate your perspective on it. Is there anybody? We got a minute and 44 seconds left.
Mr. Chairman, we have 3 speakers online.
Wow. Okay, let's go. Minute 42.
Harry Herchard, please unmute your mic
and turn on your camera.
Hi, my name is Harry Herchard. I'm a Fairfax voter and one of 12 regional captains for the Nonpartisan Convention of States project. My region covers Senate Districts 38 and 37, 36 and 35. And on behalf of the 3,800 COS supporters in my region, I ask that the committee vote aye for SB 528 to support Article 5 of the United States Constitution and federalism. Many senators in the past have not supported an Article 5 Convention of States due to fear that there were not enough controls on the process. Bill 528 is a building block to help calm those fears. Voting no on SB 528 will tend to make the 75,000 Virginia petition signers think that those arguments weren't really true. I humbly request that the committee pass 528 and allow for a robust floor discussion. Thank you.
Don Carey, please unmute your mic and ensure your camera is on.
Hi, thank you for giving me this opportunity to speak. I just got to be part of Convention of States.
Ma'am, we're going to need you to turn your camera on, please.
Okay. Okay. I keep turning it on. It doesn't seem to be coming on. Can you see me yet?
No, we can't. Time's also expired here, pretty much.
Anyway, I'm a volunteer, and I just want to say that there's so much truth about Convention of States for all people to learn. And when it's shut out, that people cannot support it because of certain regulations, well, we want to prove that those regulations are in place to protect a Convention of States and make sure that it cannot run amok. As so many claims have said, you know, the truth about Convention of States is available and everyone should be supporting.
All right, thank you. We have the last speaker. If you could state who you're with, your name and who you're with, and that you support the bill.
Yes, hello. I don't see a video. Here's a video. Really quick, I won't spend much time on this. I support
Ma'am, you can state your name. Time's expired. You can state your name, who you're with, and you support the bill.
My name is Anne Gregorian, and I'm with myself. I'm a citizen here in Virginia, and all I'd like to say is that the Convention of States is allowed under Article 5, and I would encourage and support having a process in place that should we need to encourage state rights, that it's available for us to use that process and not have to wait on it. Thank you very much.
Thank you. Okay, anybody opposed to the bill? Okay, nobody's opposed to the bill. Is there any further discussion about the bill? It's been moved and seconded. The bill be reported. Does it have to go to finance? Yes. I guess you want it to go to finance?
It's a misdemeanor now.
Well, that's a misdemeanor.
It was a felony.
Are we allowed to amend Senator Lucas's letters?
We moved the substitute.
The substitute's in, yeah. We got another motion down here, though. Hold on. What's the other motion? Okay, it's been moved and seconded. The bill be PBI'd. We'll see what we have to get there. All the clerk will open the roll.
Ayes 9, no 6.
Okay. Thank you, Senator. Appreciate the presentation and the historical discussion. And we'll continue to discuss this. All right, next up I have Williams Graves. Is she here?
She's not.
Okay, we don't have to do her yet. We have McPike, who has
Senate Bill 686.
686. This is a really tough one.
Thank you, Mr. Chairman. This is adding the Juvenile Domestic Relations Court judge for the 31st Circuit. Mr. Chairman, this has been through and approved by the Judicial Council based on the analysis and workload, and appreciate the committee's consideration of this request and the demands on the 31st, and a referral to finance along the road.
Okay, is there anybody in favor, anybody opposed? Probably not. This bill went to the Judicial Council, which is a whole process for looking at this kind of thing. It was certified.
Mr. Chairman?
Okay, Senator. Okay, some more questions down here to the left. Senator Obenshain.
Good. Mr. Chairman.
Senator McDougall.
Through the judicial, what circuits are in the bill?
Prince William, Manassas, and Manassas Park.
Mr. Chairman.
The 31st, Mr. Chairman.
Mr. Chairman.
Yes, sir.
I thought the Judicial Council voted on a number of jurisdictions,
They
not
did.
just one.
That's in the next bill.
Okay. What should we not do them all together? Is my question, Mr. Chairman.
Oh.
I mean, I guess should all the circuits moving forward be in the same bill?
Senator McPike, do you care? You want to get?
I'm not saying whose bill. I just said.
I don't know, Mr. Chairman, that it would matter in the end. From a legislative process, they're all going to be considered and go through finance and then essentially be approved as independent. I think it's important that folks have voices about what happens in their local courts and in circuits.
Senator McDougall, I see that the 31st is also in Senator Deeds' bill.
Mr. Chairman, the point was, I think when on these, there's probably pretty universal agreement that all the circuits that the Judicial Council agreed to need to be approved. So just making sure that we keep them all together.
Oh yeah, I don't think there's any intent to.
Okay.
Chairman, would you object to just incorporating your bill into the larger bill?
Mr. Chairman, I don't object.
Okay, it's been moved and seconded, but Senator Deeds moves, Senator Foy down there seconds that we incorporate Senate Bill 686 into Senate Bill 710. The clerk will open.
Appreciate the co-chief and
make
all
him
the good
co-chief.
stuff. Thank you very much.
The clerk will open the roll. Okay, McPike, you're incorporated.
Ayes 15, no zero.
Senator Deeds, why don't we do 710 while we're on this song?
One bit of controversy in 710 is that it does not include every seat that was certified. There was a judgeship certified that had some of the lowest numbers that I ever saw. And it just so happened, a member of the Judicial Council was not present because he had come to the first meeting of the Senate Finance Committee held in this. So we weren't all, I wasn't there, and they voted for it anyway, and so it's not in this bill.
25th.
Mr. Chairman.
Senator Deeds, where he used to be. Senator Obenshain.
Mr. Chairman, this is my circuit. It used to be Senator Deeds' circuit, and Senator Deeds moved to Charlottesville, and we miss him. But this has gone through the process. It was thoroughly evaluated. It was vetted. And, I really appreciate Senator Deeds' perspective, but, we have a process for a reason. And this reason that we've got this process is so that we're not going to be individually throwing around our legislative weight and deciding that one circuit needs new judges and another circuit needs fewer judges, like we did back in the 1970s and 1980s, and we had circuits in Virginia that had judges who were able to go home at noon because they had a senior member of the General Assembly representing that circuit. We have placed our trust and our confidence in the Supreme Court and in the Judicial Council. And I would respectfully submit that we need to follow that process. If we're not, it's worthless. And we're just going to go back to balkanization of our judicial circuits around the Commonwealth of Virginia. And I just highly object to the removal of one circuit.
Mr. Chair,
Senator Deeds.
if I could respond just and I appreciate everything that Senator Obenshain said. Of course, most of the time those legislators were throwing around their weight to create new seats for their constituents. But I'd ask members of this committee to look at line 45 of the bill. There are 4 general district court judges in the 25th, 5 juvenile court judges. Then look over at line 82 for the 25th. Senator Obenshain would have this bill say there should be 7 judges in the 25th Circuit. There were 3 when I started practicing law in the 1984. There was a 4th by the time I got to the General Assembly in 1992. There was a 5th added about 2012 or 2013, and a 6th added 4 or 5 years ago. And I would suggest that the workload and the population load does not justify a 7th seat. And I'd ask the gentleman to show me where in the numbers the Supreme Court looked at just shows the justification for a 7th Circuit Court position.
Mr. Chairman.
All right, Senator Obenshain.
Mr. Chairman, I would respectfully ask this to go by for the week so that we can get somebody here from the 25th Circuit to address that specifically. I'm not able to do it.
Senator Obenshain, I think he's okay going by for the week. But I want to really quick check. Staff, what's our Sabrina, or MJ, or Taylor, what's our finance deadline?
Mr. Chair, I believe we have to hear all of the finance bills by February 5th, Monday, February 5th. That's the last day.
We got plenty of time.
Yeah, that's the last day we can hear.
Okay, all right, so we got plenty of time. So bye for the day. All those in favor say aye. Aye. Anybody opposed? No. All right, so that one's bye for the day. Next up, is Williams-Grace back yet? No.
No, Mr. Chairman.
Okay, Senator Aird, batter up. Sure, if you really want to present from here, go for it.
Thank you so much, Mr. Chairman and members of the committee. Before you should be Senate Bill 481. And Mr. Chairman, I'd like to get an amendment before you and explain what that does.
We got a substitute or an amendment?
It's an amendment.
Okay. Why don't you explain your amendment?
Yes, thank you, Mr. Chairman. Mr. Chairman, the amendment would ensure that this legislation is not conflated with traffic infractions, and so it just makes that clear on line 47. And so I'd ask the committee to adopt the amendment.
Senator Aird moves, Senator Foyce or Deeds seconds the line amendment. All those in favor say aye. Aye. Anybody opposed?
Thank you so much, Mr. Chairman. Again, Mr. Chairman and members of the committee, Senate Bill 481 is about eliminating the assessment of court fines and fees and costs against youth in the justice system. Ultimately, eliminating these fines and fees, it will make our juvenile justice system a bit fairer and more efficient and effective because primarily courts will be able to utilize other interventions and resources that can be imposed equitably on all youth, regardless of economic status. Specifically, the legislation does 3 things. It eliminates all fines for youth who are accused of criminal acts, again, not to be conflated with traffic infractions. It prohibits the practice of courts charging families for court-appointed lawyers or court-ordered treatment and examination, and it preserves tools that judges can use instead of fines and fees. Again, Mr. Chairman and members of the committee, Senate Bill 481 will make our system more effective by requiring courts to use those additional tools. Some examples include community service, driver license suspension, curfews, electronic monitoring, or court order service, and to, in the most extreme cases, confinement and treatment services that can be, again, imposed evenly regardless of economic status. And so in closing, Mr. Chair and members of the committee, a number of stakeholders have worked extremely hard around the clock to find this equitable solution to these juvenile fines and fees, to include Rise for Youth, the Commonwealth Institute, New Virginia Majority, the Juvenile Law Center, and I want to thank them for their hard work on this approach. Mr. Chairman, and finally, I've worked with students in the UVA State and Local Government Policy Clinic and have with me today Bridget Harrington, who is looking forward to expressing her support of the bill and her research into this legislative approach we are taking today.
Senator, I've been detecting some concern over here to my left about your I think everybody agrees that traffic infractions ought to have fines, but I think there's some concern about some other traffic infractions you might be ignoring. Senator McDougal.
Mr. Chairman, my question was, my understanding of the definition of a traffic infraction would exclude things like DUI, the 18.2, 260, 6.1, we always call baby DUI, hit and runs.
This does
eluding.
not include traffic infractions.
But they aren't traffic infractions. Those things are Class 1 misdemeanors. They don't qualify as traffic infractions
I'm
typically,
sorry.
so you need to pick those up too if you're trying to get all traffic stuff.
Or reckless driving would be
Right,
another,
reckless
another
driving.
example.
So I would like to capture those
Mr.
things,
Chairman,
and if I
sorry.
could get some assistance from.
Yeah, hold on, wait. Let's make sure Big goes through the chair.
Yeah.
Thanks, MJ.
Mr. Chairman, I think.
So counsel, Taylor, Ms. May, do you have any way you think you could pick up sort of traffic-related misdemeanors?
Yes, Mr. Chair, if I could just have a minute to look through to see where we might add to clarify that you could still impose a fine for the traffic infractions.
Okay, this thing's got to go to finance anyway too, right?
It does.
All right, so what, Mr. Chairman
One
McDougal?
the other thing is passing a school bus. I think that.
Mr. Chairman, that's reckless driving.
There's a civil penalty that's not reckless driving.
Okay.
I think that's correct.
All right. So, Ms. Taylor, you got that? Ms. May? Okay. So while we're taking testimony, I think Ms. May is going to work on some words. So why don't we set it at 5 and 5, which we probably won't need. And all those in favor, please testify. Coming up to the podium here.
Those online who wish to speak to this bill, please raise your hand.
Good evening, Mr. Chairman and members of the committee. My name is Bridget Harrington. I am a student in the State and Local Government Policy Clinic at UVA School of Law. The views I express today are my own and not those of the university or the law school. My partner, Shelby Singleton, and I have had the privilege of working with Senator Aird to develop this legislation, and I'm here today to ask that you vote in favor of SB 481. As Senator Aird just described, this bill will eliminate fines and fees for our justice system-involved youth, and in doing so, make our juvenile justice system fairer and more effective. Really quick, just want to note that under the current system, children can be given a bill at the end of their case, which may include a fine, but largely consists of fees and court costs. These bills can be easily handled by families with financial resources, but will long remain a burden for families without means, often trapping them in a cycle of debt, which can include paying both interest and an additional 17% when accounts are considered delinquent. In short, SB 481 will remove burdensome and counterproductive costs on families who will never be able to pay them, free up court time from inefficient collection or violation hearings, and ensure that judges apply the law fairly and effectively. For those reasons and all those given by Senator Aird, I strongly urge the committee to support SB 481. Thank you.
Thank you very much. Next, please.
Thank you, Mr. Chairman and members of the committee. I'm Emily King with the Commonwealth Institute for Fiscal Analysis. We'd like to thank Senator Aird for introducing this legislation. I'd like to touch on some of the research that TCI has conducted regarding the elimination of youth fines and fees. Foremost, fines and fees are and have always been an inefficient source of revenue. Overall, fines and forfeitures are relatively insignificant revenue sources for Virginia's local communities, typically making up less than 0.5% of county and city revenue. It's even less for juvenile and domestic relations court, as these fines and fees make up less than 2% of all fines and fees collected in the Commonwealth. Further, most of the fines and fees assessed in JDR court are never collected. In 2023, there was over $8 million of JDR court fines and fees assessed, with less than 40% of that amount collected in the same year. This system is not only inefficient, but it harms Virginia's youth and pushes Black young people deeper into the system, with law enforcement officers referring Black young people to the juvenile justice system at 2.6 times the rate of young white people. SB 481 is needed to make sure that the legal system connects young people, no matter what they look like or how much money their family has, to the support and resources needed to reach their full potential, rather than placing additional barriers in their path. It is for these reasons that we urge you to support SB 481. Thank you.
Thank you. 2 minutes left.
Hi, Mr. Chairman, committee members. My name is Deontay, and I'm with Rise. And I'm a Rise for Youth, and I'm here to say fines and fees hurt our family. A lot of time we get in trouble because we are trying to help our families. We watch our parents struggle to take care of us. And when we can't work sometimes, we make bad choices. Maybe we are playing sports or trying to do good in school, but when we watch our parents struggle to feed us, buy us clothes, and keep us in our house, it gets to us. We aren't bad, we just need help. When the courts charge us fines and fees, it can lead us to getting in trouble again. Parents don't mean to take it out on us, but sometimes it can feel that way. I know we make mistakes, but when fines and fees follow us, it makes us feel like we don't deserve a second chance or forgiveness. I just want to grow into being a young adult, knowing I have a second chance at the future and not be stuck. Please vote for SB 481. So many other youth like me have a chance.
Okay, 105 left, and we have 3 people online as well.
Good evening. Thank you, Mr. Chair. My name is Ailsa McCutcheon, and I am here on behalf of Legal Aid Justice Center. For all the reasons previously stated, we also support this bill for the abolition of juvenile fines and fees. Thank you very much.
Good evening, Mr. Chairman, members of the committee. My name is Chuck Mayer, representing Julian Legal, a civil and human rights firm, and we strongly support the bill for the reasons previously stated. Thank you.
Thank you. 35 seconds.
Hello, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority. We support for all the reasons stated. Thank you.
Thank you, New Virginia Majority. Can we go on the online support now?
Taj Mahon Haft, please unmute your mic and turn your camera on.
Taj Mayenhaft with the Humanization Project and Steering Committee for New River Valley Reentry Council. For all the reasons previously stated, we support this, as well as the fact that for those with these fines reentering society after having been convicted as juveniles, it is that much more of a burden to adjust to being an adult without the normal development. And it also drives students away from school having these fines.
Okay, time has now expired. If you could just state your name, the organization you're with, make sure your TV camera's on, and that you support the bill, I assume.
Mr. Chair, Ramin Fadahi, the Commonwealth's Attorney for the City of Norfolk, here on behalf of Virginia Progressive Prosecutors for Justice. We support the bill for all the reasons stated and more.
Okay, thank you, Mr. Fadahi. Good to see you. Next up.
Miriam Dede with Juvenile Law Center. We enthusiastically support the bill.
Thank you. Let's reset the timer and go to opposition. Is there anybody opposed to the bill?
I'm sorry, Teddy Mallory with the Virginia NAACP. We support the bill.
Okay, thank you. Okay, anybody in the room who opposes the bill? Is there anybody online who opposes the bill? I believe this bill has to go to finance, correct? Okay, is there any further discussion?
I move we report the bill before.
Oh, we don't. I'm sorry. Ms. May, you had an amendment for us, yes?
Yes, Mr. Chair. I'm trying to think through where the language would need to be added, and I'm thinking that in a few places, line 225, adding something like unless it's for a violation under 18.2266 or 18.2266.1 or reckless driving under Article 7 in 46.2, and then adding similar language, possibly on line 361, allowing the court to impose a fine for those same offenses, 18.2-266, which is DUI, or 18.2266.1, or reckless driving. 448. Yes, and then also that is where the amendment that's already been adopted was added, where it said except if it was a fine imposed for a traffic infraction. So I think Senator Deeds is correct, similar language, or a violation of 18.266, 18.266.1, or reckless driving. And I think there was one other place where it looked like we'd need to account for, I think, lines 954, 955. Talks about court costs. I'm not positive we need to add it there, but it may need to be, because it already accepts offenses under 46.2 in that section, but perhaps adding DUI. And I think those are the only places.
Ms. May, we picked up speeding to elude.
I think I might have to specifically add that. I don't think that's under reckless driving, so I'd have to.
Senator, I think you're might find a couple more ornaments on the Christmas tree as we move through the process. We figured things out here because we're moving pretty quick today. Senator McDougall.
about reckless driving, there's reckless driving general, and I think there's 18 others.
Yeah, there are a bunch of others.
Yeah, I was thinking I think sometimes we reference just reckless driving under the whole article, since
Okay.
there's several things that are punished as reckless driving. So if you link to reckless driving under Article 7, it's in 46.2 is the whole reckless driving article.
Okay.
Procedurally, Mr. Chairman, are we able to move the legislation forward and have the amendment prepared by finance?
We can have it prepared. We can have it prepared.
Senator Deeds.
Concept between here and finance, and then if we need to clean it up in finance, we can do it there.
Why don't we just do that?
Yeah.
All right, so it's been moved, I think you moved, didn't you?
Or
Senator
refer.
Deeds moves, Senator Aird seconds that we report and refer the bill to finance. We'll fix it en route. Clerk will open the roll.
Ayes 11, noes 4.
Bill reports refers to finance. Senator Williams Graves here to talk about weapons in hospitals, right? What do you want to do first?
Senate Bill 515, please.
515, weapons,
Yes.
possession, facility, mental health services, et cetera. Okay.
And
Committee
we
will
do
turn
have
its
an
attention to
amendment.
Sorry?
We do have an amendment.
Okay, the committee will turn its attention to Senate Bill 515, and we have a line amendment. Here it is. Yep, okay. Senator, why don't you explain your bill, tell everybody what it does, and then explain the amendment you want to make.
Thank you, Mr. Chair and members of the committee. Senate Bill 515 establishes as a Class 1 misdemeanor for possessing or transporting a firearm and certain other weapons into any hospital that provides mental health or developmental services in the Commonwealth. The amendment simply changes in 4 areas the term facility and removes the term facility and inserts the term hospital. And so with that, I'd just like to, in April 2020, an analysis by the U.S. Bureau of Labor Statistics found that healthcare workers account for 73% of injuries from workplace violence in 2018, which is the most recent data available. The threat to nurses, physicians, and other healthcare workers has been on the rise since 2011. 64 handguns, 1,204 knives, 58 box cutters, 84 tasers, and 2 machetes. This is the inventory of weapons intercepted at the doors of emergency departments in 2 Centera hospitals since October 2022. In all, security personnel have prevented nearly 2,484 weapons from entering Norfolk General Hospital and Virginia Beach General Hospitals since October 5th of 2022. The presence of weapons escalates the chances of serious injury when workplace violence occurs in our hospital emergency departments. This bill protects staff and workers. These courageous individuals provide life-saving care to our patients at all hours of the day and night. They must be able to focus on their essential duties without worrying about whether or not they will be the target of violence or become an unintended casualty. This bill protects patients because hospitals are a bustling refuge for anyone from newborns to individuals experiencing a heart attack, a stroke, from young children with a broken bone to crime victims with a gunshot wound. This bill also protects communities because too often violence in our communities plays out in a volatile cycle of bullet-for-bullet retaliation. Innocent bystanders are killed because they were in the wrong place at the wrong time, and it should never be the wrong time to be in a hospital. Mr. Chair and members of the committee, I do have expert witnesses here who are able to testify or answer any technical questions that the committee may have.
Okay, Senator Williams Graves, we've got a lot of questions, I think, and I know Senator Obenstein has one. I had one quick sort of housekeeping kind of thing to begin with. Taylor or Steve, one of you, don't we normally put new crimes in like 18.2 instead of 37.2? I mean, wouldn't this be more appropriately drawn to Title 18.2?
Typically, yes.
All right. Does anybody else care besides me?
I mean, I think,
Senator
Mr.
Perry.
Chairman, I think it can be done either way, right? There are crimes in 37.2, there are crimes in 40.1, 103, cruelty to children. Yes, it's a crime, but it's also part of the labor law.
Okay. Let's tell, well, first of all, Ms. Mays brought to my attention that putting it in the 18.2 gets picked up it's by some, I got it. We'll get it picked up by some other offenses if we put it in that article or that title as opposed to in 37.2 for second and subsequents and all that. And so I think it'd probably be better suited, from my perspective, in 18.2. I'm not sure if from their perspective it would be, but I would move that we move this to the, what is it, chapter or the article that deals with firearm offenses. Ms. May?
I will find it, Mr. Chair. It's an article in, I think, Chapter 7 of 18.2.
Okay. Well, my motion would be that we move it to that article. Is there a second to my motion? Second. Okay, so we moved to second. We move this from 37.2 whatever to article something in 18.2 that Ms. May will figure out later.
And Mr. Chair, I think it's Article 4
Article 4.
of Chapter 7 of
Okay.
Title 18.2.
Is there any discussion about that motion?
Mr. Chairman, I just wondered, after last year and Rob Bell's retirement, who was going to become the guardian of Title 18.1?
It appears to have found a home.
I'm sure Delegate Bell is watching online and about to text me. Okay, any further discussion? All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay, so now we're in 18.2. Senator Obenshain, you had some questions.
Just real quick, does this apply to patients?
Yeah.
So somebody who's brought in unconscious, excuse me,
I'm sorry,
unconscious.
Sorry, Senator Obenshain, go ahead.
In an ambulance who is in possession of a handgun, they'd be in violation of this?
Mr. Chair, Senator Obenshain, I would say the answer to that question would be no. If they're brought in, they're unconscious. All of their personal items are generally removed so that they can be prepared for surgery or whatever life-saving measures. It would be unintentional.
Doesn't matter.
Okay.
Mr. Chairman,
Yes, Mr. Benjamin.
The answer would be yes.
Yeah.
Thank you.
Okay.
Mr. Chair.
Okay. Senator Jordan has a question, and I
Thank you, Mr.
finally acknowledging her presence.
Finally. Thank you, sir. Question for the patron. So, and maybe this is for council. So last year, I actually was in your district on several occasions, and I went between Norfolk General and CHKD on several occasions with my daughter and, by myself. And I had a small little stun gun in my purse. If I entered security unbeknownst or forgetting, and I was intercepted at a door, would I be possibly charged with a crime? I'm assuming the answer is yes.
Mr. Chairman, the answer is yes. It's akin to somebody trying to go through security at an airport. You may not know you have a firearm in your suitcase, but you're going to be guilty of the offense nevertheless.
Follow-up question, Mr. Chair.
Senator Jordan.
While I appreciate the intention, and I think the safety concern that the patron has in the bill, there are oftentimes people in the sense of duress or an emergency may have things on their person that are unintended, not intended to harm. Do you have correlating data that shows, instead of the number of people that entered the place where these items were confiscated, but rather anyone who had the police called or intention or a sense of escalation that doesn't correlate someone's pocket knife being taken at a security checkpoint?
Mr. Chair, Senator Jordan, I have experts from Centera who are here who can speak to that matter as to what is taken off of individuals coming and going out of the hospital.
Mr. Chair.
Senator Jordan.
Mr. Chair, Senator Williams-Graves, I don't think that's probably what I'm asking. I'm asking there's a difference between a person taking a pocket knife at security versus the hospital calling someone in a point of escalation when someone has an intention with a weapon. So I'm asking for that delineation if you may have that data.
Mr. Chair, Senator Jordan, the activity that you're describing probably constitutes a lockdown. And we do have members of the Centera staff who are here, who are expert witnesses who can answer the questions.
Thank you.
Okay.
Mr. Chair.
Senator Perry. I'm sorry, McDougal was first, then Perry.
That's Carol Foy.
Oh, I'm sorry. I just heard a voice out of my ear. They used to confuse me with Chap all the time. Senator McDougal.
Mr. Chairman, I hear a lot from my local law enforcement that one of the biggest challenges they have is people having to stay with an individual who's been TDO'd at a hospital, and that they have to rotate personnel frequently. So if I look at provision C, if you had a law enforcement officer that was on duty while they were at the hospital and they're relieved, so they're no longer performing their official duties when they are relieved, they still would be in violation of this as they leave the hospital.
Is that a question to me?
Well,
Isn't that true?
isn't that true? I just,
Mr. Chair, Senator McDougal, I would say that's a stretch, but I'm not a legal mind, so I'm going to defer to the legal minds.
Mr. Chairman, with all due respect, and
Senator
certainly,
Perry, you want to answer the question?
I do want to answer the question. I think that that's a strained reading of the title. Usually when those law enforcement officers relinquish custody of that individual, which is really what they're doing, they continue to be law enforcement officers who are still on duty. I think your question or your statement would apply more to someone who is getting off of duty. And typically people who are getting off of duty have some sort of other checkout procedure that they go through. It's not just walking out of the hospital.
Mr. Chairman,
Senator McDougal.
If the concern I have, and I have the reason I brought it up is because I have a bill coming up later, is the official duties term. So are you performing your official duties after you've been relieved and you're leaving? So this doesn't say that you're on duty or working from the sheriff's. It says while acting in the conduct of their official duties.
Which line are you on?
C. I don't know which line it is. I did the highlighted section.
27.
Wow, acting.
Mr. Chairman, an easy fix might
Okay,
be
Senator, Mr. Benjamin.
might be
And
to
then
simply
Carol
replace
Foy.
those words with while acting as an incident of such person's official duties.
That solve your problem, Senator McDougal.
Well, something like that.
Can you repeat that?
Instead of saying while acting in the conduct of such person's official duties, language similar to saying while acting incidental to such person's official duties.
Senator McDougal, does that make you happy?
Mr. Chairman, I'm not sure that gets it, but I don't have the exact words. I think it needs to be more around like uniform displaying a badge of authority and employed. I think it kind of probably in that direction a little bit more, because there's duties. There's been some question about remember we had this discussion of when we were passing a law enforcement officer on the side of the road and it was in their official duty. So were they after the stop was over? And you probably argued that case and were successful as well in time. So that official duties action terminology causes me some concern. We probably need to come up with a new way.
Okay. Why don't you guys play with that some more? We got a ways to go on this. Senator Carol Foy had a question, and then we'll go back to Senator Stewart.
Mr. Chairman, speaking to the bill, I think two concerns that I have is, one, we need to add the word knowingly. So this is not like a strict liability offense that you just have something on you and then you enter the hospital and then that's it. There needs to be something that you knew that you had it on your person or in your possession. And then also I'd like to see a carve out for my clients who are under emergency custody orders, temporary detention orders, paperless ECOs. These are people who are having mental health emergencies. So they're forcibly, oftentimes against their will, taken into custody by law enforcement and taken to be hospitalized. So they are not usually of sound mind to question or have a conversation about what's on your person. Sometimes they're combative, so that officer is not able to safely search them at that time, and they can be admitted to the hospital with things on their person. So I just want to make sure that the people who aren't walking into this hospital unwillingly aren't penalized in this case. So those are my just two things.
Mr. Chair, Senator Carol Floyd, kind of like the unconscious patient also.
So,
Kind of, yeah.
I don't know, Senator Williams-Graves, I'm detecting a lot of questions and some cleanup that might need to happen on this. And Senator Stewart, it sounds like you got something. I know there's some concern about whether the exceptions in the bill line up with the exceptions that we normally have in 18.2, and there's some exclusions on here, I think, for people carrying things used for food preparation. What does it say? Any person possessing a knife customarily used for food preparation and using it for such purpose, which I guess would cover the people making food in the hospital. But if you're I don't know, a fisherman and you're anyway.
Well, that's my question,
Yeah.
Mr. Chairman.
Coming from the area where there's lots of fishermen. Senator Stewart.
Yeah, what does that mean, uses customarily in his trade? So does that mean I can have a 12-inch Bowie knife if I cut hay bales with it every day? And is that any less dangerous than anything else? And shouldn't this be tied to intent and knowledge? And I'm kind of piggybacking off of what Senator Carol Floyd said.
Well, I feel like the bill has a pulse, and I think we want to probably
You want to answer that?
do something with it. But
Mr. Chairman, the answer is yes. That's a clause that troubled council when we reviewed this, but that's just one discrete clause.
Yeah, so Senator Williams-Graves, I think you need to take like a sidebar on this, clean it up some to shorten our hearing, or else we're going to be here all night to clean up. I mean, I think the lack of knowledge associated with, normally when we talk about possession of an item, you have to show that the person possesses the item, whether it's cocaine or a gun. And the way it's written right now, I don't know whether it needs to say knowingly and willfully or knowingly and intentionally, but there probably needs to be some cleanup around that. It sounds like we need to make sure, now that we have this in 18.2, it lines up with the normal exceptions in 18.2. We need to make sure that by taking it out of 37.2, we didn't lose some terms that Title 37 normally has that we haven't gotten. And I know I can see that there's a few other people here to testify to it. Yes, Senator Williams-Graves?
That was going to be my question. We do have people that came and have waited to be heard on this. Can
Okay.
they be heard? And
Sure.
then perhaps we pass it by for the week and get this language cleaned up and bring it back.
Right. Well, why don't we go 5 and 5, support and opposition, so people don't have to come back a second time, and then we'll take it by for the day after that and see where the discussion goes. How's that?
Thank you.
All right. So why don't we set the timer at 5? Anybody in support, come on up and tell us more about Senator Williams-Graves' statistics, which I thought were pretty shocking.
Hi, my name is Anna Healy James with Centera Health, and I'm here in support of the bill and thank the patron for this. Again, we saw we implemented 2 of our hospitals' weapon detection systems, and Virginia Beach General as well as Norfolk General. We found over 2,400 weapons, and this is also coupled with 8,100 mental health patients that we saw at the same time. And so we just don't think that weapons and mental health patients should be in the same area, and so we've been really supportive of this. We do have one of our trauma surgeons here from EVMS who works at Norfolk General who I'd like to testify as well, Dr. Burgess.
Good evening, Mr. Chairman and members of the committee. My name is Dr. Jessica Burgess. I'm a trauma surgeon at Eastern Virginia Medical School in Centera, Norfolk General Hospital. I work in a level 1 trauma center where we treat gunshot wounds and victims of violence on a daily basis. When patients come into our emergency room injured and scared, our team of doctors and nurses is at its best, doing everything we can to save that patient's life. During these critical times, we shouldn't be worrying about our own safety, but unfortunately we all do. The hardest part of my job is having to tell families that their loved ones have died. This is the worst moment of these people's lives, and emotions understandably run high. Especially when their family member was a victim of violence, there's a lot of anger, and it is sometimes, unfortunately, directed at me and my staff. My team and I have been threatened with violence, holes have been punched in the walls, and chairs have been thrown at me. The only consolation I've had during these times was that no one ever had a weapon. In the end, the only thing that we want is to be able to help people in their greatest time of need, but we also want to know that we'll be safe and that I'm going to be able to make it home to my kids at the end of the day. The doctors and nurses that I work with are some of the most dedicated people that you will ever meet. Unfortunately, a hospital can be a place of fear, anger, and mental instability. Adding weapons to this environment puts us all at risk. We want each person who comes through our doors to feel that they're in a safe place with medical professionals they can trust. The last thing that anyone in a hospital should be worrying about is their safety. Please support this measure to protect myself, my colleagues, my patients, and their families. Thank you for allowing me to speak today.
I have a question, Mr. Chairman.
Senator Kilfoy.
Quick question. So I understand the need to balance the safety of the staff, but then also the safety of the incoming patient. My question is, if you have a Class 1 misdemeanor for a person who may suffer from paranoid schizoaffective disorder, and they may have a box cutter or a weapon on them because of their diagnosis, do you think that having this Class 1 misdemeanor, they can appreciate it, or that's going to prevent them from having the weapon on them if they were to enter the emergency room or the hospital?
Sure, I think it goes back to, again, I'm not the legal person, but I think that does go back to what you were saying as far as like knowingly with an intent, But yes, I would agree. So, again, with a trauma patient that comes in unconscious, we take guns and knives off of people all the time that come into my trauma bay. And certainly that's, I think, a different sentiment than what the bill is going for.
So this, Mr. Chairman, follow up?
Senator Kilfoy.
So the essence of this, we're really trying to get to the bad actors, to people who are in the hospital with an intent to cause harm to staff or with malintent. Is that correct?
Yes. Senator Kilfoy, it's specifically, the people that come in either retaliation about a violent event or, with the intent of injuring a healthcare worker.
Okay, thank you.
Thank you. Okay, let's go on with testimony. Mr. Forehand, how does Inova feel?
Mr. Chair, members of the committee, Mike Forehand with the Inova Health System. For the reasons previously stated, we support the bill. Workplace violence, workplace safety is, if you ask any of our team members, it's a similar situation to what you heard from Satara. It's the number one concern of our team members. We run the fourth busiest ER in America, and this is a significant concern for our team. So appreciate the Senator bringing this bill and the interest in this issue. Thank you, Senator.
Good evening, Mr. Chairman, members of the committee. Maura Holdren with Bon Secours Health Virginia, and for the reasons stated, we support the bill as a measure to keep our staff and our patients and our communities safe. Thank you.
Thank you.
Mr. Chair, members of the committee, Brent Rawlings, Virginia Hospital and Healthcare Association. We support this legislation to protect our healthcare workers, patients, and visitors. Thank you.
Good evening, Mr. Chair, members of the committee, Lori Haas. We certainly support the bill. What we've learned and understand is building owners and private businesses can certainly have policies regarding firearms being brought into their premises, into their property. However, if someone violates that policy, their only recourse is to call law enforcement and have this person removed. When someone is armed and in the building in violation of a policy, it's just that, it's a policy, and that they have to call law enforcement to enforce their policies, which takes law enforcement away from their official duties. We certainly support the bill and the right of these hospitals and private businesses that provide these services to regulate the presence of weapons. Thank you.
Mr. Chairman,
Hey,
we
Ms.
have
Haas.
one online speaker.
So there's one?
Just one.
One online speaker. Turn on your camera and speak up. 58 seconds.
Virginia Rovnak with the Charlottesville Coalition for Gun Violence Prevention and the Charlottesville Center for Peace and Justice. For all of the wonderful reasons given, we strongly support this bill. Thank you.
Thank you. Okay. Is there anybody else in support? Nobody. Okay, let's reset the timer and hear from Mr. Van Cleve.
Those online who wish to speak in opposition, please raise your hand now.
Yeah, how'd you guess? Mr. Chairman, Philip Van Cleve, Virginia Citizens Defense League. One thing I would say, especially for concealed handgun permit holders, disarming somebody does not make them safer, not in this universe anyhow. And doctors and nurses, some of them have permits if it's a dangerous thing. I know if I was a doctor or nurse, I would like to have some way in an emergency to protect myself. By the way, I got a hold of the Virginia State Police and got statistics on permit holders, and you have no exception in here for there. Maybe that's something you should do. Revocations for any reason, and there's a lot of reasons. Let's say they're all crime. It's 0.1 of 1% of permit holders that had their permits revoked for any reason. That's about as law-abiding as you can possibly get. So if nothing else, there should be an exception which would allow people that have the permits, have done everything the state wanted of them, that should have proven themselves to be perfectly trustworthy to be allowed to have firearms in this place. Thank you very much.
Thank you, Mr. Van Cleve. Anybody else opposed in the room?
Mr. Chairman, we have 2 online.
Okay, got it. We have one more live.
Thank you, Mr. Chairman. Dennis O'Connor. I'd just like to point out that the most dangerous places in America are those that have created an artificial environment where people have their ability to defend themselves removed from them. And we see that specifically in schools, where we're going to continue to see massacres of children because we've laid out the red carpet to any demented person that wants to get a high body count and go in there and not be stopped by anyone else. And what this bill does is create that same dangerous environment in hospitals now. I urge you to kill this bill. Thank you.
Thank you. Okay, let's go to the online testimony. Turn on your camera. And we got 2 people?
Pat Webb, please unmute your mic and turn on your camera.
Good evening, Mr. Chair, members of the committee. I'd like to say that the patron of this bill did not say whether the weapons that were confiscated in her statistics were being used in a threatening manner, or if they just were confiscated because it was against hospital policy. Were they confiscated from patients who were coming in maybe unconscious after a traffic accident or a heart attack or something like that? So the statistics that were presented, I'm not sure what bearing they have on the actual threat being presented here. Also, these facilities don't strictly treat mental health patients. They treat people that maybe are having babies. They do treat victims of violence, and those very victims of violence may need a family member there who is legally armed to protect them from the person that just attacked them. So, there's not always police there to protect you, even in a hospital or emergency room. So I urge you to oppose this bill. Thank you.
Thank you.
Ann G., please unmute your mic and turn on your camera.
Yes, Ann Gregorian, I'm speaking for myself, and I would like to speak to something a little different, more personal, and that my husband, a 26-year Army veteran and expert rifleman, is a concealed carry permit holder, and we have 3 children. If there was an emergency and he happened to run in without taking off his concealed carry, it's my understanding from this bill that he could be charged with a Class 1, and I would ask that there be some provision in here for people such as my husband, when it's brought to his attention that he has a weapon, to either return to the car, to surrender it without getting charged. I'm sorry, Senator. Without getting charged, thank you, without getting charged with a misdemeanor.
Okay, I think that concludes the testimony. All right, Senator Williams-Graves, I think you got a little bit of work to do. One other thing you might want to look at is whether signage might be a good idea. And I had some questions as well about whether or not the term hospital, whether that includes the building or the parking lot or beyond. And so I think might need to do some more draft to make it a little clearer. So,
Mr. Chairman, just while we're on that topic,
Senator Perry.
I had a question just about whether something like a scalpel would qualify as a knife, any other medical tools that would be in the environment. This bill currently criticizes or criminalizes possession, and so just making sure whatever carve-outs we need are there.
Okay, thank you. Got your instructions?
Yes, I do. Mr. Chair, may I just simply add that hospitals are traditionally a place of healing and safety. People come to the hospital to be healed and not to be harmed. And in the growing instances of violent episodes, we just want to make sure that hospitals remain that place of healing and of safety. So with that, I would ask the committee to pass this by for the week. We will do the cleanup with staff and the other stakeholders and bring it back.
Great. Thank you, Senator Williams-Graves. And I know you have
2 more.
Are they quick at all? Because we're everybody's getting hungry.
Whatever will get me to a yes with the committee, if it's coming back next week because y'all have a full belly, or pushing through it now.
Oh, yeah.
Mr. Chairman, I'm fine with continuing to go. I'm continually reminded by the chairman that there's 106 bills left. We only have a couple weeks, and we get the countdown all the time and told that this, that, and the other.
Yeah, I know. Thank you. Thank you, Senator Perry. You got the cracking the whip down there. We have about 90 left. I think one or two more that can get referred to us. We have how many meetings left? 5 meetings left, so that's 90.
You can knock them out.
86 left. Yeah. 10, 15. They say it's better than average. You do? Oh. Okay, listen, we have 2 housekeeping things we can do really quick while we're distracted here. Hold on, Senator Williams-Graves. First of all, Senator Obenshain's 691 needs to be re-referred to Ag. So Senator Deeds moves, Senator Bagby seconds. We re-refer Senate Bill 691 to Agriculture Committee. Do we have to record that? We don't? Okay, all those in favor say aye. Oh, that's what I meant. Okay, open the roll, please.
Ayes 15, no zero.
Great. And then secondly, another administrative thing I think we do. Senator Bagby, can we roll in your 587 into my 259 so we don't have to... Okay. Okay, so Senator Bagby moves, Senator Deeds seconds to roll Senate Bill 587 to 259. That's the class action bill. We'll take that up on another day. You open the roll. Incorporate and list him as a chief co-patron, or chief patron.
Ayes 15, no zero.
Say why? All right, Senator Williams-Graves, I think what I'm getting is we got 2 really quickie ones we can knock out in 5 minutes. Yours are probably going to take at least 10 each. So I think we're going to invite you back on another day.
Anyway, Mr. Chair.
Okay. All right. Thank you.
Thank you.
But I hope you got some good feedback on that one. And
Absolutely.
right.
Thank you.
Good. So, Senator Stanley, you got 589. Why don't you explain your simple little cleanup bill?
Yeah, 589. Mr. Chairman, members of the committee, we made some modifications in 2019 of Title 55 when it related to non-residential tenancies, and there was a technical error. We put it in the wrong spot in the code. So this scintillating bill that will change the world basically relocates certain provisions of 55-1, that is the title under property and conveyances, related to assignments of rent from a chapter related to non-residential tenancies to a chapter related to leases. Oh, wow. I need to put this on a brochure. It is so awesome.
Okay, Senator Stanley, is there a motion to report Senator Stanley's brochure bill?
Move to report a bill that could have been read quicker than that.
Okay,
well, if you and Obenshain weren't fighting over judges, we would have been out of here a half hour ago.
All right, Senator Deeds moves. Senator Stanley seconds that his bill be reported. All those in favor say aye. Aye. I'm sorry, we got to open the roll. I'm sorry, that's my bad. Okay.
I want to hear him talk about it again.
Ayes 14, noes 1.
Okay, and then staff recommends we take up one more bill, which is my bill.
Mr. Chair.
Yep. What? Yes, Senator Williams-Graves.
I have been made aware that there are folks who have traveled a great distance to testify on behalf of SB 654. Is it remotely possible for them to testify and we can go over the bill next week?
Sure. We're happy to do that.
Okay.
Which bill number is that?
I'm sorry.
654.
I'm sorry, 514. I'm sorry, 514.
Oh, 514.
Yes.
Okay. So why don't we take up Senate Bill 514? MJ set us to 5 and 5. Can you set the table just really quick? Senator Williams-Graves, tell us what we're looking at.
Sure. Senate Bill 514 simply reduces the period of collections from 60 years to 10 years for court costs and fines. It does not do anything to include restitution, but it is important to note that this piece of legislation seeks to bring criminal collections in parity with civil collections of court costs and fines. Currently, we're at up to 60 years. We'd like to bring it down to 10 to bring it in alignment with other states such as West Virginia, Washington State, Arkansas, Tennessee, Texas, Oregon, and North Dakota.
Okay, thank you, Senator. I have a bunch of comments from the work group here, so this one I don't think is simple, but we're happy to take the testimony. So why don't we go 5 and 5, MJ, and hear those in favor, and then those opposed if there's anyone.
Those online who wish to speak to this bill, please raise your hand now.
Time's a waste. Go on.
Go, fire away.
Good?
Welcome, yeah.
All right, thank you, Chairman and members of the committee. I'm Emily King with the Commonwealth Institute. We want to thank Senator Williams-Graves for bringing this legislation forward. Virginia's 6-year statute of limitations for court debt collections makes us an outlier among states who cap their collections at 10 years. This unusually long process has real-world consequences for Virginians whose lived experiences should help shape future solutions. I'm here for technical questions, but the individuals here today speaking to the personal ramifications of the outstanding court debt provide just a glimpse at the impact these costs and collections can have statewide. We urge your support for SB 514, and we encourage you to hear their stories today.
Thank you. Come on up really quick. I had a question for council. Maybe Ms. Mayor, Mr. Benjamin. Did this 60-year thing come up as part of that restitution compromise back in like 2000, maybe 14, 15, when the larceny threshold got adjusted? I remember we made a bunch of changes to restitution back then. Is that where this came from?
Mr. Chair, I don't know if it was a part of that, but I can tell you that it was changed from 20 years for circuit court and 10 years for general district court to the 60-30 in 2018.
Yeah.
So
okay.
It was recently changed, but I don't know if it was a part of those
Got it.
changes.
All right. That gives you some context. Okay, go ahead. Sorry.
Okay, hi. Thank you, Mr. Chairman and members of the committee. My name is Melissa Trinidad. I have personally experienced negative impacts of outstanding court debt. In 2019, I was charged with over $20,000 in court fines and fees. After 5 years and paying every single paycheck for the last 5 years, I still have over $8,000 to pay off. Making these payments have affected my ability to pay off my student loans, purchase a home, and pay for my kids' college education. If the statute of limitations for court debt collection was reduced from 60 years to 10 years, I would experience significantly less setbacks in resuming my daily life. It is for these reasons that I urge you to support SB 514. Thank you.
Thank you.
Good evening, Mr. Chair and Senate Committee. My name is Hassan Shabazz. I am the president of Prisoners' Rights Clinic and Public Relations Officer for Freedom Over Everything. And I support this bill specifically because I was impacted by the statute at a time when it was 20 years. I did 23 and a half years in prison, and what allowed me to be able to come home and actually be successful is that all of my fines were wiped out after 20 years. Right? And so over $7,000 in fines I did not have to pay when I came home. And I've been able to succeed and be successful and do a lot of different things in the community since that time. And so I think that reducing the statute, it was increased from 20 to 60, right? So reducing it from 60 to 10 would impact so many different people. So I think that in doing so, it would be great for the Senate Committee to support this bill and support this bill as well. Thank you.
All right, 2 minutes, 15
Good
seconds.
evening, Mr. Chairman and members of the committee.
Yep.
My name is Alan Brothers, and I am with Real Life, and I was impacted by this. Even though my court fines and fees were just a little over $3,000, I was able to pay them off and get some of my credit ratings back up, but I've also seen others within our program be impacted by not being able to build their credit or even get good paying jobs. So I'd like to say I support this Senate Bill 514.
Thank you, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority, and for the reasons that you've just heard and many more, we support the bill. Thank you.
Thank you.
Hi, my name is Ruby Charan. I'm an attorney with Legal Aid Justice Center, and we also support this bill for the reasons stated. Thank you.
Thank you.
We have one online speaker, Mr. Chairman.
Okay.
Please unmute your mic and turn your camera on.
In this bill, Virginia Progressive Prosecutors Justices in
I will keep 1 minute and 8 seconds back.
Mr. Fadahay, I think your internet connection is a little glitchy, but we get the gist that you support the bill.
Mr. Fadi is my Commonwealth's attorney. He
Right.
supports the bill.
Norfolk, got it. Got it. Any other buddy in favor? Anybody opposed to the bill?
Those
Nope.
online who wish to oppose this bill, please raise your hand now. There's no speakers, Mr. Chairman.
Nope. Okay. Well, I did a little bit of legislative history. It looks like it was Senator Norman's bill originally that did this, and it passed the Senate unanimously. And in the House, there was a few people that voted against it, including somebody named Delegate Jennifer Carroll Foy. But in any event, I guess we'll hear this. We'll talk about it some more next week.
Thank you. Thank you,
Okay.
members of the committee, for hearing
Great.
the witnesses.
Yeah, and thank you for coming out today. And I'm sorry things ran late. Things ran late on the floor and pushed us late. With one more bill, council suggested that we might take up, which is my bill, because it's cleanup, which is Senate Bill 509. Direct the committee's attention to that. So, Senator Deeds, you want to take over?
It's about time.
So, ladies,
Bill 509, is there anybody here that wants to speak in favor of that bill? Got a motion to pass the bill by indefinitely, and it's been properly
minute.
seconded. Please open the roll.
Wait a minute.
I thought we were trying to hurry things up, Senator Servell.
Okay. So here's Senate Bill 509. We passed a law last year that basically banned interlocutory appeals in divorce cases, and it turns out, and we asked the Family Law Coalition to study that. They studied it and said we went a little bit too far, and this basically just says that divorce cases are subject to the same interlocutory appeal rules as every other case. And so it references 801 675.5, which means you'll barely ever see an interlocutory appeal, but there's that little safety valve in case it's ever necessary. Family Law Coalition supports the bill. I'm not aware of anybody that opposes it. That's what it does.
Is there anybody here from the Family Law Coalition to confirm
This
what
just puts it in line with
Senator Servell's just said?
Appeals. Okay. I move to report.
Anybody here in favor of this bill?
Those
Anybody
online
in
who wish to
opposition?
speak on this bill?
Is there anybody online? I think Senator Stewart had
No
a
one
bill,
online.
had a motion of report. Is there a second to that motion?
A second.
Are there other motions? Is there further discussion? If not, please open the roll.
Ayes 15, no zero.
Okay, your bill's reported.
Okay, we've emptied the room. Thank you, Mr. Chairman. We've emptied the room. We'll be back Monday. I know we're going to do some more of the firearm
Mr.
bills.
Chair.
I'm sorry?
I have people that came a very long way
Oh, okay.
on my bills. I know we did that for everybody else. Would you offer that indulgence?
Yeah, sure. I didn't know there was anybody else. I'm sorry. Do you want to take testimony?
Yeah.
Okay.
Thank you, sir.
All right. Sorry. Let's see. Which bill is that? Senator Jordan, we got
637, sir.
637. Collections. Notice concurrence of clerk. Senate Bill 637. Okay. Senator Jordan, you want to give us like a
I'll give you a
30-second version of what this does?
I got it. So Senate Bill 637 would allow concurrence of circuit clerks of court to weigh in on the process and selection of a vendor in regards to collections in between the circuit clerk of court and the Commonwealth attorney. Currently, right now, that only resides with the Commonwealth attorney. They can either go with a private collection agent or they can utilize the Department of Taxation or other public bodies. I do know there is opposition to the bill and there is support to the bill. So if anyone would like to hopefully briefly do so.
Okay. So why don't we set it 5 and 5 really quick? Are you a... I'm the one and only. Okay. You're a clerk? Okay. Okay.
If you'd like, we can just take this outside.
No. Okay. I like the guy. Okay, so let's go 5 minutes in support and 5 in opposed. Fire away. Sir, where are you the clerk?
My name is Randy Carter. I'm the clerk of the Circuit Court of the City of Suffolk, and I'm here on behalf of the Virginia Court Clerks Association.
Great. Thanks for coming.
The bill basically before you is that right now, a Commonwealth's attorney can pick the collection agent I work with every day, and I have nothing to say about it. Absolutely zero. And I'm sort of going to play off a thing you asked Senator Servelt. Says, how many times has this happened? Happened to me. And it happened in Portsmouth. So it happened. What this does is it basically says that the clerk is to be consulted. And let me just say this. Once they sign that agreement with the collection agent, they're out of it. The everyday handling of it and all of that falls on the clerk. They get a report. I'm sure they get a report from whoever it is, but they don't collect it. They wouldn't understand how to collect it. I would point out, too, that in this bill, it says it can go to court debt and the local city treasurer without us even asking. Why is that? Court debt's cheaper than private by 3%. So you're charging more people who are on the hook, 3% more, and we don't have a say in it. This is critical stuff. This is money that's owed us. And I think as I'm the collector, I should have a say in how it's collected. Not the total say, I just want my say. So if there are any questions from the panel, and thank you, I'll be happy to answer.
So I just had a quick question. Do you have any other idea how many other circuits where we have a conflict between these two constitutional officers? Have you guys done a survey of it?
I have not, sir, because this thing came up this year. It came up this summer. I was at the beach when I found out about this.
Okay, got it. Anybody else in favor?
Mr. Chairman, we have one speaker online.
For this, wow, they're still here.
Mr. Chairman, can I ask a quick question?
Sure. Senator Stewart has a question.
Why isn't this an issue for the Board of Supervisors? Ultimately, they're going to pay for this anyway, right? Or no?
No, sir. The fees are generated through the collections.
So they're taking a cut.
When someone gets convicted in court, their fines and costs assessed. If that right now under the law, if it goes delinquent more than 90 days, it goes to collections. Once it goes to collections, it goes to that collection agent. They get a tax 17% on top of it right off the get-go.
Right.
And then 3% more after that. So the Board of Supervisors, with all due respect, sir, do not pay for this service.
Got it. Okay. We have somebody in support online. That's amazing.
Mr. Chairman, it would appear that they left.
Okay. Okay. Opposition. Let's reset the timer.
Good evening, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, and speaking on behalf of the Virginia Association of Commonwealth Attorneys. We are opposed to the bill. We tried to find anywhere else in the code where one constitutional officer told another constitutional officer what they could do or how they should fulfill the responsibilities that the legislature has imposed upon us. It has been imposed upon us to both to decide how those fines and fees are going to be collected when they go to collected. There are a limited number of options, but there are options. And one of the options is to use a third-party vendor. There are third-party vendors that have been used that do not do a good job, and they do not continue to be used. But there are some that do an excellent job, and there are Commonwealth attorneys that would like to continue to use those third-party vendors that are doing an outstanding job and who have a tremendous amount of customer service built into their collections so that they know that when an individual has fines to be collected, they're not going to be told, if you're not paying $100 a month, then you're not paying any. They will work with them on the amount and on a payment plan that a lot of times the Department of Taxation won't do or the Treasurer won't do. So this is a matter of choice for the local Commonwealth attorney to decide what's best for their locality and for the citizens with regards to how these fines and fees get collected if they do in fact go delinquent. Completely agree that we should do all that we can to build the relationships with our neighbors down the hall. For me, it's on the same floor. We should communicate with them, we should talk with them, get their input, but to say that they have to agree and they get to have a say in the decision is just a step too far. And so we would ask that the bill be passed by.
It sounds like y'all need like a mediator. Senator McDougall, you had a question?
And maybe this is for each of you. What is your perception under the way this is written if there is no agreement then what happens if you can't concur?
That's a good question, and maybe if a friendly amendment would be is the local judge, your local circuit court, your local judges decide it. But there has to be something.
Mr.
I mean,
Chairman.
it's sort of like me telling the Commonwealth's attorneys what case management system in their
Okay, hold
office
on.
to use.
Yep. Senator Stewart has a question.
I wasn't thinking too straight a minute ago, but aren't the Commonwealth's attorneys charged under the law to collect these? Or am I not remembering that correctly?
Mr. Chair, or that is correct, and Nate will correct me if I'm wrong, but in this section, it does say it shall be the duty of the attorney for the Commonwealth to cause proper proceedings to be instituted for the collection and satisfaction of fines, costs, et cetera.
That was my recollection, was that they had the responsibility under law to do
Stewart. Yeah. Should they do the cause proper proceedings to be instituted for collection and satisfaction? Okay. Okay. Any other questions? Senator Peake.
If it's the Commonwealth's attorney's duty to collect it, how do you end up doing it?
Because
How come
we
clerk?
collect all the fines and costs. And I would also say the Commonwealth's attorney wants it, they can have parts of my accounts receivable for monies I don't raise. I'd love to give it to them.
Well,
So I don't have it. But once they decide it, it comes to us. Here's how I found out, Senator Peake, just to answer your question. This summer, I'm at the beach. I'm sitting on the beach. Phone goes off. Guess what? Somebody from the Commonwealth's attorney's office down here wants you to sign something. I said, what is it? They got a new collection agent. That is the first I heard about it.
Well,
and we
Mr.
have
Chairman,
to do the everyday work on this thing. How do we monitor it
But
if we don't?
that's
Hold
my
on, Senator
question,
Peake.
Mr. Chairman.
Senator Peake, then
Why,
Senator Dees.
if it's the Commonwealth's attorney's constitutional duty or statutory duty to collect it, why is the clerk of court collecting it?
It's,
Hold on. Senator Dees, do you have an answer to the question?
I think if you just look at the code sections, constitutional officer's duty to cause proper proceedings to be instituted for the collection and satisfaction of the fees, but the money is sent to the clerk. The money's deposited with the clerk. It's got to be statutorily, it's the duty of the Commonwealth attorney to collect.
Mr. Chairman, it's because the Commonwealth's Attorney's
Senator,
Office
sorry, Senator Perry. Go ahead.
doesn't want to deal and touch with the money, right? So it goes through an office that does.
So, Mr. Chairman.
Hold on a second. Wait.
Apologize, I
We're
apologize.
going to open dialogue here. So, Mr. Green.
We do not collect the money if a third-party vendor is asked to take part in the collections. They don't deliver it to us. They deliver it to the clerk's office. The clerk is the receives those fines and fees that were collected in some way other than the normal course of showing up at the clerk's office and paying on time. If you go into collections, then somebody else is going to be doing the collections, whether it be a third-party vendor. Some local attorney, Commonwealth attorneys decide to do it themselves. That's a very small number. Or Department of Taxation gets involved. Either way, regardless of who is collecting those delinquent fines and costs, once they are collected, they are paid in to the clerk's office. There are difficulties, and I do appreciate that if a third-party vendor is used, they will use garnishments and things of that nature, which require additional filings by the clerk's office. Some clerk's office love that because it means they get to count all those filings when it comes to adding additional staff to their office. Some hate it because it's additional work.
Mr. Chairman.
Senator McDougal.
Are all fines and costs collected through the circuit court clerk's office, or if it's a district court fining cost or juvenile for a matter that might not be juvenile related going forward, aren't those collected in the district court?
Mr. Chairman, that is absolutely correct. There can be three different choices for the three different courts. You could use third-party vendor for those fines and costs that are in circuit court. You could use Department of Taxation for those fines and costs that are in juvenile and domestic relations court. And you could do it yourself for those coming out of general district. Or you could use the same. But it's an independent choice is made for each of the different courts.
Okay. So Senator McDougal.
Mr. Chairman, in the way this is written, circuit court clerk would have to sign off and agree for each of those jurisdictions, the way this is written.
That is, Mr. Chairman, that would be my understanding.
Okay.
This is what I got from the Commonwealth.
Sorry, Mr. Carter. Hold on. You just don't get to speak. So, Mr. Carter, what I would suggest is we we take this by for the week. And Mr. Carter, my caucus decided we wanted to allow virtual testimony, so you can be available by Zoom if there's more questions or discussion about this.
I will come back as necessary.
Okay, got it.
I'll make myself available.
Got it. Okay. So, but this is going to clearly take some more time, and everybody's like wanting to walk out the door here, and so we got to get back at full strength. So, nobody else testify. We're all good. Committee will rise.
Senate of Virginia, Richmond, Virginia.